My lord, the bail matter, AB, similar petition against the same FIR is listed tomorrow. Tomorrow. So it may also be listed tomorrow. Obliged.
Madam, let me mention item number 30. I have received some instruction from our client lordship that matter has been charge sheeted lordship, but I also the learned PP informed me they didn't have received any report. So lordship
Adjourned for the day.
or adjourn lordship because
Yes, for adjournment of the day. When should I fix it?
after 1 week, maybe they update the report.
Tuesday, 23rd.
Lordship.
Yes, there is not received.
Okay, okay.
Me, please, Your Lordship. Lordship, I beg to mention for listing of an anticipatory bail. Lordship, for motion, Your Lordship. May this matter come on day after tomorrow?
Day after tomorrow.
Yes, Lordship. Obliged.
Sorry. So the thing is that lordship, the matter has been already been registered as a PRC case, lordship.
Uh-huh.
And
Ah.
the matter fixed on 30th of October, lordship.
Okay.
So lordship, the report may be updated before that.
No, is it confirmed? So
I have no such instruction.
we fixed it on day after tomorrow. On
Lordship.
23rd we fixed.
Lordship, lordship.
Okay, that case, okay, so should we call for scan PCR? Charge sheet and CD will do. Or should it come? Let the matter come. It is Tuesday, right? Let the matter come on maybe Friday
Lordship,
instead of Tuesday,
lordship.
Friday.
Lordship, interim order is there that I think.
The interim order shall stand extended till the next date of listing. List on 19.
Lordship.
So then on that day, perhaps we can make an order for procuring whatever is necessary.
Lord.
Right?
I beg to mention for item number 38, Lordship. 30. I have taken the consent from other side. But adjourn the matter for the day.
For adjournment, the matter for the day, the consent of the other side. Prayer is allowed. We want it to be fixed
On
on
18, Lordship, day after tomorrow.
tomorrow.
Suspension of sentences. He has undergone already more than 1 year, or the punishment is 5 years.
List on, can it be on Tuesday, 23rd? Next Tuesday,
It possible, Lordship, day after tomorrow.
18/9.
Obliged, Lord. Please, Your Lordship.
So there's a series matter starting from 41, item number.
Hearing.
Yes, my lord. I am in 42, my lord.
Okay.
My lord, for the last 12 years, I have no contact with the client. I need to
Yeah,
find
whole
out.
matter.
my-
Actually, I'm just experimenting, because the hearing matters are not getting listed. So I'm just experimenting whether this will work. If it causes inconvenience to councils, I'll change again.
No, my lord. it's
Yeah,
better. Since
before
the start-
vacation, I'm just saying. Because before vacation, today and only one more day, Thursday. And thereafter, a few days after vacation, let us try. If it doesn't causes any inconvenience,
Since it
then
has come.
we'll adjust, then we'll modify. This you want to adjourn for that.
For after vacation, so that we can contact the client.
No
And
problem.
the series matter. in fact, I have
Suddenly
told
I-
41 and 40.
This notice came suddenly. I understand. No issues. But locate him and let us do the matter.
Exactly.
Matters are pending. Series will be from 41 to
41 to 45.
45. Council.
TK Bhattacharya and 42.
Some submits that these are old matters and there's some communication gap with the
My lord,
meeting.
My lord, my friend is appearing in 42. It seems the client was given notes. So I'm no longer in 42. Okay, my name still will give him that.
Listen. So I'll record his name.
Yes.
Planet Council. Good name.
JK Kusumi Lordship.
That's all. Then what should be the reason for adjournment?
Lordship, can you fix the matter after vacation? Lordship?
My own
Yes,
matters.
all.
These are summits that being old matters. There is some time to prepare for the
Lordship.
same. It's an adjournment. And for listing after the vacation. Prayer is allowed. Kindly, vacation is also there. Prepare it.
Lordship, I will.
Let us.
Lordship, we received the paper books, Lordship,
No.
but the exhibits, Lordship, the paper books we received, Lordship, But exhibits are not, yet to, it is yet to furnish.
I will also need the paper book. It is submitted that though paper book has been prepared, but exhibits are not available. The paper book sections shall provide the exhibits to the learned councils. Copy of the exhibits to the learned council. And also to the, it will be there for us, for the court, because I have not seen the paper books. And if needed to the prosecution as well as be placed before the court. Least after vacation, should I fix a date? Better to fix a date.
Not.
It can be in November also, but it should be a date, right?
Yes, Lordship,
where
in
should I
November,
fix
Lordship, any day, November, Lordship,
November.
any hearing date.
Lordship, I am there in item number 41 and in 43.
Okay.
But in this, your lordship, I don't have any communication with my client, appellant, your lordship, since 2014.
So
So I am seeking that CBI may collect some information, whether it is live or dead, I don't know.
problem actually. As far as date is concerned, one possible date can be.
Lordship, November, Lordship, second or third week of the, of November.
I have
Lordship.
some problem with the date of November, your lordship.
When you do prefer?
December first week, I am
It's too late, you know, because see, it's been-
November last week. your
appeal has
lordship.
been pending for 12 years.
Lordship, November last week, Lordship.
Lordship 27, 28, I'll be possible. 27 and 28, I'll be possible.
27, 27, 11.
Must have lost.
Much of them.
Just imagine, appeal has been pending for 12 years.
Yes, Lordship,
The
oh,
incident would be of 10 years back.
yes, Lordship.
Five lordships. But maybe lordship, if I don't get the information.
Kindly
instructed-
try to get that information.
I will appeal.
CBI should be burden CBI with this at this case, whether to find out what. Because
whereabouts.
this is the council's responsibility, actually, but if there's a information that he is there, suppose.
Yes, yes.
Someone is there,
Oh.
this person. Then see, the police, the investigating authority can try to get a report.
They have the address, your lordship.
They have that list. Try to find out.
My lord, I am appearing for item number 44 and 45. And in item number 45, we did not receive the paper book, but in item number 45, we have received the paper book without exhibits, my lord. So kindly may direct the appropriate. authority-
44.
44. 44 did not receive any paper book yet,
Same paper book, the exhibit.
With exhibits.
Furnished to the councils.
as per order dated 27/3.
Common order. So what did Actually, I'm sure nowadays the part tool is in the conventional sense, earlier sense does not come. But advanced list comes, right, for the councils, advanced list. So this must be, once a matter comes in the advanced list, it is my duty to start preparing, start locating, because otherwise they will never be heard. Just never be heard. It's 12 years appeal is pending. Anyway, I'm giving you the date, same date, November 27th.
Obliged.
So let us do the homework within that period.
Yes,
So
ma'am.
that whichever bench is there, 27, hearing will start. Because otherwise when this will be disposed, right? November 27. No, I'll accommodate, no problem, but let us start the process. Anything else? Any more motion, any more mention? First half only I'll take care. Second half I'll take up the bails, don't worry.
Lordship, this is the appeal against
We take with him, yes.
but the respondent has not been represented by anybody. And the notice has been already served. There is a order dated 19/8/2019.
Let me go. Passage of time, everything becomes our memory, these things, everything becomes difficult. 1/8/18,
19/8/19.
19/8/19. This whole response.
Nobody has appeared on behalf of the respondent.
Okay.
So my prayer is maybe amicus, maybe
Amicus, yes. Or These kind of matters, it may not be essential. No,
Because if
appointing an
he's not-
amicus is always a good idea.
Yes, because if
Good
he's not
idea.
represented, then he will be
Have
again
something,
convicted.
but in
Yes.
that case, we'll not be able to have the hearing. We have to give him some time.
Yeah, exactly. But he has already been given a lot of time, so my case will be if lordship thinks it's fit. Or may give some more time for the service.
Last order was on in September 2019.
24/9/19.
6 years.
Yes, coach. But nobody has appeared for respondent number 238.
Have you gone through the brief? I feel like it's acquitted, right?
Acquitted, yes, it's an NI Act matter.
Your good name, please.
MS Hussain on behalf of AM Bora.
MS Hussain, Learned Counsel MS Hussain, hearing on behalf of Learned Senior Counsel and AM. Draws my attention to the order dated 10/9/2019. Sorry, 19/8 to 19/8/2019. It is revealed therefrom that though service upon respondent number 2/complainant, those is service upon sole respondent/complainant has been completed, but none has appeared for him. So, the PCR has been received. Anybody from the prosecution is not there. Sole respondent, the sole respondent. So in that case, we have somebody has to be present. So in the interest of you must have abandoned the interest of better adjudication. Three, Sarfaraz Nawaz appointed as amicus to represent the sole respondent/complainant. He may be furnished a copy of the necessary documents on the case by the registry. In that case, we'll have to list after vacation on any suggested date. Any date will actually be after vacation. 30/10. 30/10.
Much obliged.
If you're saying, wait, let him do it. I feel like it's a principle. Let us see what then proceed to that. They said will not, even if hearing is not, they will not go beyond Asaf. 56. Recent order is there. Till 5. Settlement. Against conviction. State continues to be a formal party to some. So it is not necessary. NI conviction. Huh? Formal party. So 2019 appellate judgment. Appellate judgment. For 6 years. The instant revision has been filed. Just for reference. So it's been filed by the petitioner against the appellate judgment dated 27/8/2019, upholding the conviction and sentence under section 38 of the NI Act, recorded by the learned trial court within bracket additional CJM handbook in CR case number 604 superscript C 2004. Respond. No, no, so let him come, then we'll decide how to proceed. If he wants to do it, I'll take up. Or if he wants some accommodation, it's really directed, let us see the appeals in the first term, the hearings in the first term. So let him come, then yes, say. First time. What about revision? Just what about for the respondent practice? Revision counsel will be necessary. Petitioner counsel. Yes. Who's the petitioner counsel? Any ideas? Mr. Ganguly, A. Ganguly. He has to come. Otherwise, he will not be able to proceed. After some. Rush. This is a state is there, washing of charge sheet. It's comparatively improvement. Washing of charge sheet, right? So. Council is not there. Just see the materials, the case that I justifies charge. Right? Hmm.
In this case, I'm sorry, my lord, here, my lord, the matter has been settled. In fact, my lord, case from
You are appearing for the petition.
for the petition.
Charge
What has happened, my lord?
You are agreed by the charge sheet.
No, my lord. Here, what has happened, my lord? In the meantime, my lord, there was a writ petition which was filed by the writ petitioner, my lord. The petition in the instant case. And in fact, my lord, in the case, the matter was referred to mediation. And my lord, there was an agreement, is basically between the husband and wife. And my lord, and the matter has already been settled in mediation. So, my lord, there is an understanding, my lord, there is an agreement. My lordship will just, I'm not doing the brief, I'll just bring the brief and place the document.
Are you in a position to do the matter?
Yes, yes, my lord. Yeah, even the other side, my lord, the lordship will have, now, since the matter has been settled, my lord, the lordship can even
Now
pass
the
the,
work is already done.
yes, in fact, my lord, we have to assess, the divorce has also materialized in the matter.
Take some time, after some time.
After some time, I'll just
we'll try to take it.
lordship.
You have difficulty, then we'll fix another. So, 48. In this criminal petition, petitioner is seeking quashing of proceedings pertaining to PRC number 1227 of 23. In bracket, GR number 895 of 23. Pending before done additional CGM Durham. Becoming learned additional PP, appears for response number 1/8. Whatever. None appears on behalf of the petitioners. And the response number 2. This after vacation. This after the vacation. In second week of double pay. Criminal revision. Along with a criminal petition. One is criminal revision, one is criminal petition. Two matters, connected matters.
Case now order of setting this this one order. What for this is? What are the system? That the order against the okay. I have come for passing the entire this.
Yeah, the criminal petition. You were the first party in the criminal revision. Pertaining to the.
And the other party before the executive scheme.
Okay. You are the petitioner and the criminal petition. And you are the respondent here. in this revision.
Yes.
The revision has been filed, agreed by the dismissal of the.
Dismissal of the attachment order by the successor.
So are you in a, should be other parties not there?
Yes. If the right parties.
Today itself. Maybe for some time, some of it is possible, then you can look in, otherwise you fix it after. Good. Good. Now we can start with the game.
Regular value petition regular, CD may be called for in this case.
Third learned confirmation and additional, he brought up for additional people. Call for the case diary of Boroma, case number 61 of 2020. Under section. Okay, the accused is stated to be in custody since 2/8/2025. List on suggested date 24/9 for failure.
So in this case, the CD has already called for in Milord bail application 2499 of 2025, listed on Milord 23-9. So Milord CD may further listed along with the other ones.
Are they? Call for the case diary of Nunmati PS case number 142 of the 25. This is the matter on 23/9/2025. Should we give the along with
Bail application 2499 of 25.
bail application number 2499?
No.
Twenty-three. Or this one, so. Prosecutor, that support ground PS case number 41 of 25. The accused is stated to be in under trial detention since 27/7/2020. List on 23/9/2020. That's a regular bail manner, Washington loot tax manner, page 16 manner. I am a recipient of stolen property manner. Page 16 manner, alleged recipient. Yes, manner, stolen property. Yes, page 16 manner, grounds of arrest manner. Your lordship will find manner, number 2 manner. On interrogation, accused number 1 admitted his involvement and disclosed that he had disposed of the stolen ornaments by selling the same to the accused number 2, 3, and 4. I am for the 2, 3, and 4. Now, lordship number loot manner, the seizure manner, already seized manner, page 19 manner. One pair. Description of this below manner. One pair of child bangles. 3 pair of silver bangles, 1 pair of pile of silver, 2 fingers, those items. We have purchased it, my lord, of rupees 5,000, my lord. Already, my lord, 17 days behind the bar, my lord. There. And they Satgaon. All for the case diary of Satgaon, case 157 of the 305 DNS. There are 3 accused persons herein were arrested on 31/8/2020. Yes, ma'am. List on 19 or 22. Satgaon, what it's 22. They have learned a lesson already. They have learned a lesson already. Law says that if the person knows that it is stolen, then only it's wrong. Yes, that will be a matter of trial fact. Dispose of the things.
Maybe the lordship regular bail lordship FIR page lordship 8 lordship it was arrested on 36/2020 lordship. Today lordship 78 days behind the bar lordship. Lordship co-accused already allowed to go on bail lordship after appraisal of the case diary lordship. Actually, this serious 103 is there, but CPP already further submitted that the FSL report also shows that the negative report of presence ethyl alcohol in the viscera of the deceased. From the postmortem report, it also reveals that it may be a case of suicidal hanging lordship.
Right? Which PS?
Satchalmara PS case.
Will it come on Friday?
Right.
I can fix it, but will it come on Friday? And allow.
Then
Reporter. Use this stated to be custody since 29/6/2020. In connection with South Salmara PS case number 67 of the call for the case that list on 22 will be better.
obliged.
Regular bill,
The petition, the accused hearing was arrested on
22/8,
22/8/2022.
22/8,
22/8/2022.
25.
2022/8/2025, seeking regular bail in connection Manikpur PS case number 91 of them. Call for the case diary. List on 24.
May I please, Your Lordship? This is a regular bail application. Your Lordship. The petitioner is in custody since last 55 days. Statutory period is 60 days. Lordship. FIR Lordship is at page number 15. Lordship. Section 1091 is here and 1091 Lordship, it has two parts. The first part says that Lordship, if heart is not caused, then 60 days, and if heart is caused,
Attempt to murder.
Attempt to
Yeah,
murder.
it is. Same as before.
Yes.
Same as, punishment is different depending on whether heart
depends,
is
yes,
caused or
Lordship. Yes, Lordship. So if heart is not caused, then it would
60
days. 60 days. Lordship. And if we go by the FIR, Lordship, even the ingredient suggested there is no allegation of heart. Lordship. It is not. And the vehicle in question that has already been recovered.
allegation. Mr.
Emma,
Emma, important. The,
on the 22nd.
the exist. It's stated to be, he was arrested on 24.
24/7.
24/7. Who was arrested on 24/7/25 in connection with Nagorbera PS case number 24 of 2025. Is seeking regular bail. Call for the case there. List on
22nd, my lord.
26.
60 days would be complete.
Then the second will be 60 days.
21st
61st day. Then still we will not
21st
do
would
any
be,
calculation.
21st would be 60 days, 22nd would be 61. 22nd.
22nd. Submitted by the learned counsel that the statutory period will be over on 21st. For my reference.
Yes, Lord. High level.
Bill application might not sit, may be conform, my lord.
But you are Mr.
M.A.I. Hussain.
MEI. MEI. Call for the case diary of Boroma PSP 61 will verify. The accused, two accused persons hearing were arrested on 31/7/2020. If same FIR, the bail has been fixed on 24.
Cannot be on 25, 21, I will not be there. 25, then you stay live.
Then we'll have to retain the case diary. Okay, 25. 25 then.
In this matter, I've been in the jail since this before days. It's connected with that about 25 of 28.
Yes, that is written here. Along with 25. After some time. It's with 34. 50 or something. At 34. No. 25 then.
In this case, Lordship, no FIR has been lodged, Lordship. Police will telephonically inform me, Lordship,
calling for the, calling to the police station. Okay. And lordship, but if that they, I repeatedly asked them, any case has been registered, or in fact, my relative got gone to the police station, lordship, but they did not say anything, lordship. In fact, lordship, I am the, I'm running a ZTech mobile repairing center, lordship. Page 4, lordship, I specifically mentioned my para 3, lordship. Maybe in totally call for lordship.
Mr. Hope,
Lordship, I'm on behalf of Hawk, lordship.
is
Is all, my lord.
learned counsel for the petitioner. Was filed this petition under 482 PNSS with apprehension of arrest, though at the moment the petitioner does not have details of any case or FIR in the Lunatic police station. Mr. Botaku will call for a report.
Yes, sir.
Call for a report. You
It will
should,
be on Friday, lordship, Friday.
if it comes, no problem.
It is the Friday, lordship, Friday.
From Lunatic PS as to whether any FIR has been filed against the petitioner Jayadul Islam or any case registered with regard to at the said police station. List on 19/9/2025 for the report.
Obliged.
After some time.
May I please your lordship? This is charge sheeted matter. Charge sheet is on page number 17.
Page number
17, 17.
17.
Relevant portion is page number 18. May I read? On 1/12/2020, one Mr. Anamika Kaur, wife of so-and-so, lodged and written FIR before Kalimganj police station against an unknown person. Accordingly, Kalimganj PS case number so-and-so was registered under section 420 and 379. 420 and 379. During the course of investigation, the statements of the informant and other witnesses were recorded. The plea of our place of occurrence was visited. A sketch map was prepared and CCTV footage from Gitanjali showed, along with ATM card replaced from the victim, was seized. In the course of investigation, one person, namely Selimuddin, was identified, interrogated, arrested, and forwarded to the Honorable Court. I am not Selimuddin. During the investigation, the said accused discloses name of his associate, Hassan Ali. Hassan Ali is the present petitioner. Hassan Ali, resident of so-and-so. A WT message was accordingly sent to Churaibari PS for his arrest, but it was learned that he had shifted to Kadamtala. Though he was searched at new address, he could not be found. It was further come to the light that the said accused are also involved in Karimganj PS number 1232 2022 under section 420 and 379. This is the case, Your Worship. Now, I have been served notice from Judicial Magistrate First Class, but charge sheet has been made under section 420, 379 and 413.
430. 430.
Therefore, 413, it has been made sessions tribal. So there is an apprehension of arrest and detain. And I am not an habitual offender because no multiple cases are there against me.
Where it has been alleged that they are habitually in their plan.
In the, no, in the charge sheet,
Yeah.
in the charge sheet, but if we go through, page number, 20, page number 20, para number 21. In this particular charge sheet, there is a column, previous conviction with case reference. It was empty.
No conviction.
Yes,
Some
no
case
conviction,
might be raised.
only one case against
Registered.
me, only one case. I will appear and I will cooperate with the trial procedure. Maybe, I may be protected. Nothing is there, nothing was recovered from me. I was not in the place of occurrence. I was not there. No allegations was made against me.
Let me have a look. You want to read the FIR, the charge sheet?
Yes.
Yes.
Yes, I'm, yes, yes. Protection may be given, I will appear.
But trial court will only be able to give bail because 413 is punishable with life also. That is true. That is true. You're right.
Your lordship, only one case is against me.
Some like any accused should not benefit by absconding. Sometimes it happens like this. To remain absconded during the investigation period. Anyway, the AP number, so the heard
Are they?
are the England council. Important. You are appearing on behalf of Mr. You are the
Yes, sir.
council. Will be important for additional people. The instant petition has been filed under 482 PNSS, seeking anticipatory bail for Hassan alias Hassan in connection with GR number 3141 of 20 under section 420, 317, 413. The Yes, smooth. Anyway. In the Azhar dated Azhar was dated 1/12/20,
1/12/2020.
2020.
2020.
The Azhar is, the FIR is dated 1/12/20, self lost by one Anamika Kaur. The investigation resulted in a charge sheet against the two accused persons, including the present accused, under section 420, 379, 413 IPC. Full stop. It is stated there that name of the present accused, though not mentioned in the FIR, comma, has emerged from the statement of the arrested co-accused Salimul. It is also stated that both the accused persons are also being prosecuted in connection with Korimgon's case number 1232 of 2015. The learned counsel submits that willing to appear, cooperate with the trial. On the other hand, the learned additional PP objecting to grant of bail submits that these are serious offences. Out of the charge sheeted penal provisions, Section 413, apart from the sessions travel, is also punishable up to life. Therefore, the learned court of magistrate may be constrained to grant bail to the accused with regard to the said penal provisions. As already stated, the name of the present accused petitioner has emerged only from the statement of co-accused. And as he was not found during investigation, he has been indicated as an absconder in the charge sheet. In the given facts and circumstances, you have the considered view that the petitioner should be given an opportunity to participate in the trial with some protection, with some should be given an opportunity to participate in the trial in the larger interest of the prosecution. Accordingly, it is directed that in the event of arrest of the petitioner in connection with 30,000 at 17, subject to satisfaction of the arresting authority. To the satisfaction of the arresting authority and subject to the condition that he shall appear before the learned court below. Any date is fixed in the future? Any date is fixed in the future?
17th of this month.
17th of this
Tomorrow.
October. He shall appear before the learned court bill on the next date fixed. And thereafter appear regularly during the trial upon commences. He shall also make the condition also. Number 2, he shall not hamper or damper evidence. He shall not try to influence witnesses. He shall not have violation of the bail conditions might entail cancellation of instant bail application stands allowed and disposed of by aforesaid terms.
Obliged.
May I please, your Lordship? Lordship, here is a case where a victim boy committed suicide. And Lordship, there are total 4 accused persons. The owner of the garage, he is also granted bail from the Honorable Guwahati High Court. That was here. And I am Lordship worker in that garage along with 2 other co-accused. Other 2 co-accused are also granted anticipatory bail by the Sessions Court. Lordship. Now, Lordship,
Let us see the FIR.
yes, Lordship, FIR is at page number 11. It is type copy, translated copy. And Lordship, as per this FIR, the informant, who is the father of the victim, he has seen everything. From the narrative of the FIR, he has seen everything. And Lordship, in that case, he is also a abettor of his son's suicide, Lordship. Why he didn't stop his son from committing.
Can you read the?
And anyway, Lordship, my humble prayer is that the Lordship interim may be granted.
Okay, let us see the.
Yes, yes, Lordship, page number 11. Our lordship, the fact is that the boy committed theft.
That's a different
And-
matter.
And on the direction of the owner of the garage, I says him, it is true, along with other two co-workers of the garage. Now lordship may kindly peruse page number 90. The order passed by this honorable court granting bail to the owner of the garage, who is the accused number one, the main accused. In his garage, the boy committed theft, and as per the instruction of that owner of the garage, we other three co-accused persons says him it is true. lordship. And other two persons are granted anticipatory bail from the court. Order is annexed. Both the orders are annexed. Annex C, page number 22. Yes, please. Annex C, page number 22.
It's really a very small boy, 12 years old.
Yes, lordship, yes. I'm similarly footing as per the orders passed by sessions as in regard to other two co-accused. Much.
The water bill, please. Very unfortunate incident.
Yes, very
Alleged incident.
But fact is very clear that yes, the person that says the victim boy thereafter. Because committed theft and lordship. Thereafter, immediately thereafter, he committed. Maybe a case of suicide. It's there, but the fact is that, immediately after chasing the boy by this accused person. Some of the and how many people at that point of time CD assembly was not.
Yeah, no, immediately after choosing, how did he commit suicide?
That is the one of that creates a suspicion.
Yeah, because in front of people. Yes, in front of the public view. How can someone blame himself?
That's why lordship interim anticipatory bail was granted to the other co-accused. This is the reason.
Yeah. it's- But
With
like,
protection.
small boy has died, so. Anyway, he go by learned counsel.
Sorry, lordship, Z somewhat. He
Sure,
engaged
sure.
in
He's some learned counsel. He got a. Petitioner seeking anticipatory bail in connection with Omalpur PS case number 82 of 2022. So someone learned counsels. So the petitioner has taken the course to the FIR dated. So
3/7/2025.
3/7/2020. One young boy aged about 12 years died and supposedly committed suicide when he was chased by some persons, by some of the accused persons, pursuant to his alleged involvement in a theft. When can you get the case there? Want to see the case there you will get this. No, get it earlier. Komalpur, right? Can you get it on 19? 22. The learned counsel prays for interim protection on the ground that three other accused persons have been given such protection. However, at this stage, I would, I'm inclined to peruse the case there for taking a decision in the aspect of bail. The call for the case diary of Komalpur PS case number 82 or 25. 19 won't be possible. Yes, 19. Just hold up 2 days. The scene.
Page please. FIR is at page 10.
Page 10.
Page 10. Start on page 2. The long FIR laid by the bank.
basic allegation is misappropriation about 6 lakhs of rupees by one bank employee, namely Dhiren Bashar, by making forged document and putting forged signature. And the allegation is that by this document, he advised the officials of the Bhanagar branch to remit this amount to some fictitious non-customer account. So basic allegation is against one individual. Now he has already been arrested and granted bail.
Who's this person? Petitioner.
Man, he is an employee of the bank. Man, he's an officer of the bank, man. Our grievance is that, my lord, the bank, the higher ups in the bank, my lord, they believe there would be the connivance of some officials.
Usually that is believed.
Yes, so that's why the police are calling this. Otherwise, no allegation, absolutely no allegation. In fact, earlier, my lord, some officials of the bank who is also been called by the police, they approach this call and they are on the interim bail.
Just,
Please, can we see? Can I
flip through the.
Yes, please. Page 11, your lordship will find these suspicious transactions were entered and initiated by Mr. Dhiren Bashar, who misused his position and knowingly transferred public funds to fictitious or unconnected third-party accounts without any supporting documentation or authorization. The funds were routed through non-customer accounts and the same were deliberately masked to appear as legitimate refund transactions.
Total about 6 lakhs.
Around 6 lakhs, 5.5 million, around 6 lakhs.
Prosecution. Forcing the signature by the forcing letters like a post and also.
That's why Dhiren Bashar.
Legally, but we have to register. His involvement has to be.
I'm only on interim.
Economic offense. Yeah, definitely.
Earlier officers, my lord, they are already on interim.
The petitioner, so and so, namely so and so, Raghu, Robertson, and is invoking provisions of section 482 BNSS seeking pre-arrest bail in connection with Bhanagar PS case number 90 2025 under section 4. The case arose out of the FIR dated
23rd of May, man.
23/5/2025. Lost by an official of the Punjab National Bank. The gist of the allegation is fraudulent banking transactions amounting to rupees approximately 6 lakhs. The one Dhiren Bashar has been named in the FIR and attributed with the main role of these fraudulent transactions. The present petition is stated to be a bank official, as he has been called by the police for examination on apprehends arrest, and hence this petition. The learned additional public prosecutor submits that the nature of the alleged offense is serious and the involvement of this petitioner remains, has to be investigated, if any, has to be investigated. The learned counsel for the petitioner seeks interim protection. Call for the case diary of Bhanagar PS case number 90 of 2025. The question of interim, there is no doubt and about the seriousness of the alleged allegations and the learned additional PP has rightly contended about the same. The involvement, if any, of the present petitioner and the bank official in the matter of investigation. However, since he is not named in the FIR and no allegations attributed to him, therefore, at this stage, it may be fair to give him an opportunity to appear before the IO with interim protection and record his version of events. In such view of the matter, is directed that in the 30,000 months satisfaction of the arresting body and subject to the condition shall render full cooperation to the investigation. Appear before the IO and making himself available for examination. He shall not in any manner hamper or tamper with evidence or try to influence any witnesses. Violation of bail conditions might entail cancellation of the bail. This is the matter mentioned. After vacation, 15 cases. This after the vacation on 15/10/2020. Much.
Report was called for lordship. Report was called for lordship.
Oh, it's no. After some time.
Can you come tomorrow, lordship? Can you come tomorrow, lordship?
Tomorrow. It can be.
Yes.
It's convenient for you tomorrow. No problem.
Yes.
On the prayer of the learned counsel for the petition, this is the matter. Tomorrow, that is. 17. Obliged.
Item number 52 as per technical instruction.
Yes, yes. No FIR also. So at this stage, we can close it. There is a, you will make your submissions. Something, there's some development against you, then you can come.
I'm appearing on behalf of T show. No problem. I fixed on 19 also.
Yes, sure. Feel comfortable. Feel com- The, actually, this, any written, nothing.
Yes. Get a written.
Let it, no problem. No, you can do it. Heard your good name?
S-U-T.
Yes,
SUT. S-U-T.
yes. Learned counsel appearing for the petition and we portable learned additional. Instead of, it is submitted by the prosecution. But as per telephonic instruction, it has been informed that no case has been registered against the petition in the said police station. However, the learned additional people submit that he can also procure a written communication in this.
Right now, my friend has 6 people, so what's up with this?
Further, last time. Further, is also submitted that in the meantime, one written communication has been received from the concerned PS through electronic mode within WhatsApp, stating the same facts about non-existence of any case against the petition in the police station as of now. In view of the same, there is no basis at the moment, right? So we can respond. If there's some development, you can of course always come in. In view of the above development, the apprehension of the petition regarding arrest is baseless at the moment. Therefore, the instant petition for anticipatory bail stands dismissed as not maintained. Needless to say that if there is any adverse development with regard to the petitioner in the future, he would be at liberty to take recourse to the due provisions of law. Petition stands disposed of, therefore, terms.
Your lordship, charge-sheeted case, your lordship, this is second application, your lordship. FI is on. FI is on.
Earlier rejection was fine.
Yes, your lordship, I have annexed the order.
All the people. Then
Lordship, my case is non-compliance of section 47 and 48 notice, your lordship. And the petitioner's mother is also seriously ill. I have annexed the documents also.
it is which section? Also.
No, your lordship, rape, your lordship, section 64 BNS. As per my instruction, prosecution witness has been closed, your lordship. Then to
Lordship. And the allegation is under section 103(1) of BNS, Lordship. The affair is at page 9, Lordship. Here is the allegation is that the petitioner, the wife, and she allegedly killed her husband and buried in the courtyard. And by today, Lordship, 65 days as on today behind the person. So, to the lady, Lordship. My submission is that, my instruction is that there was some actually altercation in between the husband and wife. The husband is actually himself drunkard. He always comes and beats the wife. And suddenly, in one night, there was some altercation and he was intoxicated. And during the altercation, he fell down and succumbed. That is my instruction. However, she is behind the bar for last 65 days. And by this time, the investigation might have progressed to some extent, Lordship. And she has a minor daughter also, Lordship. She is still going daughter. And there is none to take care of her. So my humble submission at this stage is that considering the length of detention and made the petitioner face the consequences in the trial, Lordship.
Diaries received.
Yes, is there sufficient materials? See, herself,
So, 201 section is also given. Any material to indicate his submission on the instruction that habitual drunkard, so one day.
The 164 was also recorded, Lordship, and there might be some something to support the instruction.
For the investigation, the other person helped her in burying the dead body.
See impact of face.
But the assaulter, the alleged assault is by herself.
Yes. See impact of face in presence of this is how should be.
But yeah, the 164 statement of the victim is also relevant. It also said that earlier also used to torture his wife and go ahead.
That is not the 64 statement of the
Child.
child.
So initially she did not bother when he was not available. Before police. Hard, so additional. So, instant bail application file have been filed under 483, section 483 BNSS, seeking regular bail for accused Rahima Khan, stated to be in under trial detention since 14/7/2025, in connection with Jalukpari PS case number 300 of 25 under section. The case was registered based on an SR dated 13/7/2025 by one Juran Ali. The gist of the allegations is that the present accused assaulted the victim / her husband, leading to his death and buried his body. Buried his body in their courtyard, which was subsequently recovered by the police. The learned counsel submits that the deceased was unfortunately a drunkard and used to commit torture from the accused. The learned additional PP submits that submits on the basis of the case that the investigation has revealed prima facie complicity of the present accused. And also another, what is the name of that person? Another person named Ghulam Nabi Azam in the criminal act have used the case diary placed before the court by the learned additional team, liking important portions. The investigation materials state that the said Ghulam Nabi subsequently assisted the accused in burying the dead body of the deceased. It is stated by the IO that after the victim died, the present accused panicked and called the other person, hiding the dead body. The statement of the minor daughter of the victim and the present accused is available, indicating her age as 14 years. The said daughter stated inter alia that on earlier occasions also her deceased, her father used to torture and beat her mother and go away from the house for several days. And that due to this, she had initially not bothered about his absence from the house. Despite the materials, keeping in mind the other circumstances that have emerged prima facie, I deem it fit to grant bail to the accused at this case. In such view of the matter, the accused, what are the line? The learned additional PP objects to the grant of bail. So we back to this. I think it's fit to grant bail. Accordingly, the accused Rahima Khatun is allowed to go 25,000. She shall not abscond. Number 2, she shall not hamper or temper violation of bail conditions by entail cancellation. return the case that the petitions is disposed of.
CGM come.
Yeah, concern on it, what will you write? CGM.
Different.
I mean, metro.
Metro.
No, Jalukpur.
Yes, yes, Metro. Develop.
Last one is also city was called for. City was called for.
Yeah.
Here, item number 2036.
20.
26 and 55.
You want to take it now or little later?
Or my statement record on 12th of September.
Not reflected. You must have submitted, but not reflected. Up to this. So we extend the interim. That's not very reasonably recent, but this aspect. No problem. It is submitted by the learned counsel for the petitioner that pursuant to grant of interim pre-arrest bail, the petitioner has appeared before the higher and his statement has been. No case diary has been received. It is submitted by Mr. Kaushik, learned additional people that the same is up to date only up to 23/8/2000. And the statements of the petitioners for the IO are not reflected here and seeks to get an updated case diary. Where is allowed, the case diary may be sent back and procured again. Procured again after the latest stage of investigation. Incorporated therein. Meanwhile, the interim protection granted by order dated stand extended with the next date of listing.
Next date will keep. October.
Last day don't keep. After vacation. Later. List on 16/10.
After 18. 22nd October.
22nd October. List up to the vacation on 22/10/2020. These are item numbers. I just ordering.
Number 2036 and 55.
2036
I take 55.
and 50. And 55. No problem. My convenience of this one. 55.
Here was called for, I can take it. Wrong here has been said.
Oh. Yeah, no, it's a PA.
Regular bill.
Regular.
Your case number 10, he lordship is your to tell the IPC. That was while between the two parties enjoying the bihu.
Here will be required here.
This year,
This year required 10,
since he is in custody since 22/4, let's
145 days. Therefore, this year.
Mr. Kaushik Larnat additional PP submits that though at scan TCR has come, but it inadvertently pertains to another case.
I am saying here actually. Here properly.
Placing may have been.
Wrong.
That is likely.
Some mistakes. But here is from 12. This case belongs.
Sure. So that case pressed.
Press. But first. I think they will again locate the.
If they can locate it, will be easy access. So accordingly, the TCR pertaining to Your PS case number 202 of 25. Scan TCR may be procured by the registry. This on before vacation. Yes, 23, 24. 23 or 25. Is 24 okay for you? 24.
Valuable.
24 now.
22 lots, same.
Same?
Same, my lord, here also same, my lord, same, yes, same affair, my
Same order.
same,
Same date also.
same day.
Same. 21, 20.
Maybe taken up separately.
Not taken. But it will, I'm not giving a tagging order. Same day.
May I please your lordship? Lordship, it is a regular bill. Lordship, seating of the call for dated 0509. When I'm, lordship, as per my information received, charge sheet has already been submitted. Investigation may be completed, lordship, and further investigation may not be necessary, lordship.
What is this provision? Homicide.
Lordship, 103, I am charged with 1031. Lordship, I have annexed the FIR, you can go to page number 11 to 17.
One zero three is couple, that's not amounting to murder.
Murder,
Forgetting the BNS.
murder, lordship.
302. Yes. So then magistrate only. So we have to get session tribunal. So on sessions tribunal, they can get bail. One of the orders, I'll try to put that order late and children. Yeah. Earlier there was a revision bench order, but anyway. So, but like capital offense, no, not possible. Scan TCR. Can we go?
Lordship, I have a small submission, Lordship. Lordship, I am the mother of a 6-year-old sick daughter, Lordship. Lordship, I have enforced a medical subsection regarding her illness. Kindly go to the page number 28, 29. And Lordship, I am not the prime accused in this case, Lordship. My husband already in judicial custody in this case, Lordship. Lordship, I was arrested after 2 months of the commission of the offense, Lordship.
Charge sheet is confirmed. Third, the
Mr. R.
no. Still in custody since
Yes, Lordship.
since
Since last 27 years.
recently arrested.
Yes.
Help me with the Azahar.
Lordship, kindly go to the page number 11 to 17.
Environment is
41
serious. Serious offense. She was arrested later. No? She is not
Yeah.
named here.
Yes, yes.
She was charged. She was arrested later during investigation. I think. 483 bail application. The bail for accused Jonali Talukdar was stated to be in judicial custody since 20 this act. In connection with Nalbari PS case number 202 of 25. The allegation is about the present accused and her husband trespassing into the house of the informant, assaulting the informant's husband, resulting in injuries and subsequent death. So, it is submitted that initially the present accused was not arrested. And she was done so subsequently during investigation. So it is submitted by the learned additional DP, Mr. Kaushik, that in the meantime, investigation is completed and charge sheet has been submitted already, including against the present accused. The petitioner counsel has submits that the present accused has a 6-year-old child suffering from some ailment. There was the next medical documents. The learned additional PP objects to the bail. However, considering the completion of investigation, however, despite the serious nature of the alleged offences and the present accused being charged sheeted, considering the completion of investigation and the minor child and the minor child of the present accused, is hereby allowed to go on bail of rupees 25,000 once sheriffed by the. It is subject to the condition that she shall not abscond, she shall not hamper or temper limits violation. Bail petition stands disposed of by proceedings, allowed and disposed of on proceedings.
Lordships, can I take an item 25, my lord, single?
Yes, 24, 25 and 14.
I'm for 25, my lord. This is a regular bail, my lord. The page number 13 is the FIR, my lord. It's 13, 813, 13, my lord. It's the FIR. This looks like, my lord, a cyber crime and committing fraud in the bank, my lord. That's the allegation. Cyber fraudsters, nefarious activities. Those they've written, but it looks like, my lord, no crime I could find my from that committed.
The allegation.
Yes, but
Is that
today is the 56th day, my lord, today. And detention period is 60 days, my lord.
this kind of cases, yes, effort should be made to submit the charge sheet. Sometimes not practically possible. Many things have to be investigated. Access my 3,000 from there, another links.
Last paragraph of FIR, it says, my lord, suspicion, only a suspicion this
That's
is
true. The allegations are serious. What is the progress estimation? Progress is that my lord, they are able to find out some my lord, fact my lord, there of the my lord, from another 2 person. That part my lord. Only that. But I will my lord, seems to have some my lord, mobile phone to other things my lord. The accounts for the
This petition is from Kerala, my lord.
Yes, to my 60.
56th day to be. My submission is on suspicion, my lord, can it be done? Unless they have committed certain crimes. With the offense that it is here is, if you commit certain crimes, you'll be convicted on these sections. So if there's no commission of crime, whether that will sustain. detection of suspicious activities.
Just. They're stated to be involved in a racket. One case. But him learned counsel and they was so learned additional people. The bail application is not the accused Gautam Sibu Lina stated to be in custody since
7/20 minor
23/7/2025 in connection with Dispur PS case number 200619 of 25 and that's going to section. The list of the allegations is about suspected involvement of the named accused persons in fraudulent activities, financial transactions and financial cyber crimes. Duping innocent persons of their money. Full stop. The learned counsel, Mr. Nath, learned counsel submits that they have been implicated primarily on suspicion and already completed 25 days in detention. The case diary has been received. Learned additional PP submits that investigation is still continuing the various aspects of the matters. I perused the case diary has been placed before the court. I have perused the flag portions. The IO has prepared a detailed note which is available in the case diary. As for the stated that as per the investigation, one PR Ali and Farooq are stated to be mastermind behind the cyber fraud racket, and that the present petitioners were stated to be in Guwahati for the purpose of such crimes here. At the behest of these two alleged masterminds. It is stated that efforts are on to apprehend these two persons. It is also stated that multiple account details and QR codes of different persons are found in the mobile phones of the seized mobile phones of the petitioner. So the iOS strongly objected to the grant of bail, submitting that projecting his contention that it might be detrimental to the investigation. Though 55 days has passed since the arrest of the petitioners, even during the remaining few days, the investigating authorities should be given a chance to complete the investigation. In the same situation, the bail petition stands rejected at this stage, we can take the case. In case it does not.
My lord, can I submit one thing?
Yes.
Let me submit, my lord. Lordship may fix them at 23rd. The reason is, my lord, within 23rd will be 60 days completed. If they cannot, they can file the charge sheet without issue.
You can take it from your.
If they cannot, my lord, if they don't, my lord, the lordship will consider my bail on 23rd, my lord.
Let it be. So you can take it from this statutory bail, anyone can take, any court can.
But should they be,
Which time?
but doesn't make much difference, my lord, because, but doesn't make much difference, my lord.
Which are same. Three matters are same. Three matters are same. These are very serious matters. You duped of your hard-earned savings. You can take your measures, but still, anyway. Of course, I appreciate your professional. We have to do our professional. We are disposable. Just for the mention, additional, I'm saying that the criminal law, or not, but yeah, law 9.10. Criminal law, all laws, including criminal law, and so also keep pace with the times. You know, in this context, you know, I feel that there should be more categorical offenses where the option of seeking extension of time for investigation should be. Now it is conventionally only in a very serious like NDPS, NDPS, UAP. One straitjacket formula does not arise. Now, in these times, there are financial crimes to be investigated, cyber crimes to be investigated, where police is not fully prepared, so they take time. So there should be a provision for extension. Court will reject if it is not justified. It's not automatic, because these sometimes are necessary. Because the thing is that quality of investigation is most important. Hurried charge sheet, you know, may not have hurried charge sheet. Hurried charges may not have. They should get proper time. Today, the investigating of financial crime is much more difficult than maybe investigating homicides. Traditional. Anyway, this might be out of context. These new challenges are, and our statutory provisions have to keep pace with that. I'm not at all an anti-liberty, very pro-liberty, but people also have to be protected. Item number 26, source matter.
Charge sheet already filed, minor. And today is 126 days.
Which section?
Section is minor.
Homicide.
Lordship, minor, your lordship will find 24 minor prosecuting witnesses.
I see.
So charge sheet file, nothing happened till today. Charge sheet filed on 6/8/25. Page 17.
Detailed narration of the charge. Are you aware of the gist of the offense? Prosecutor. What exactly happened?
The question I know because from investigation computer. No, this is the one thing I'm saying.
That's all it meant. Only one person charged it.
No, no. 1%.
Order of one additional session just appears.
Yes, man, 1%. Page 18, man. John Mohammed present petitioner, man. Only page 18, your loss will find serial number 10. Page 1. Only 1%.
Scan copy not resolved.
Everything will come. Let's see.
Word, HRH, senior counsel, assisted by IUH, what's word, gave also additional good stuff. The present accused, Jan Mohammed Ali. Jan Mohammed Ali alias Raju Ali is stated to be in judicial custody at present since
13/5/25.
13/5/2025
126 date today.
in connection with Gorsuk PS case number 150 of 2025.
TRC case number.
Which after completion of investigation resulted in a charge sheet against him on 6/8/2025 under section 1031/1152 BNS. Certified copy of the charge sheet has been annexed. The charge sheet has been lodged only against the present accused.
Yes.
Under the aforesaid sections. And 24 witnesses have been listed therein. And the case is stated to be at the stage of appearance before the learned court below.
Yes.
And poised for committal and subsequent proceedings. As per the due proceeding system. Though scan copy of TCR was called for, but it was called for, right?
Yes,
But not yet received. Mr. Boshna, learned additional PP objects to grant of bail this test. Considering the nature of the, considering that the case is one of alleged missing. However, considering the completion of investigation and the length of his under trial detention, I'm of the considered view that subject to suitable conditions, used can be released from bail at this stage. Such view of the matter. 30,000 with 1 students. So subject to the conditions that he shall not have shall not hamper or temporary limits. He shall not intimidate or harass the informant or our family or any witnesses. In case of violation of bail conditions, the prosecution can move an application, cancellation of the same. For the learned trial of this. Shall.
Trial not started. Trial not started. This is not CBM.
Yeah, see. An application for cancellation. That's all.
CBM Kamrup Metro.
With satisfaction of the concern learned. Right. CJM Kamrup Metro petition stands allowed in this.
Chief, our case file was important. Chief.
Yeah.
Case of FIR number page 10. There is my relation, my love affair. And applicant was going to marry in the month of December.
Hit me with a wood on my head and split my head, and that means some kind of fracture, reverse injury. Medical report, I think. It's not wise to see things.
Short date now.
Anything else you want to say? Submitting.
Regarding my lord that all the offences are below 7 years, my lord. And my lord, offence which has been given, my lord, it is in respect of my lord, 2 couple year or 1 couple year also. Because of some confusion and some suspicion, there was my lord altercation between both. The allegation that I already married, it is not correct. Your lordship.
31/8.
Minus.
CD has been received. Mr. Goswami learned additional people. Some means that though CD has been received, but medical report is not, and that the same may be necessary for this bail adjudication. Finding force in the said submission. Issue requisition for the medical report while retaining the case date, right? But you can retain. Thana, which Thana?
Gitana. Guwahati.
My locality.
Date number.
Released on 23. 23, okay. 23, that is likely to be off. On your 23, list on 23. or the medical.
This will may take it to this case, my signal will be.
We can, either we can do that, or
Whenever be available.
after you finish,
Yes, take
if time permits.
you can.
Yes.
Regular bail application matter. CD was called for. I was registered on 49 matter. Lordship can see, I will be lordship grant for a FIR matter. My lord, it is purely an accident, man. Now, my lord, I am not going to go on very because except 105, all are bailable sections, which are mentioned here. So your lordship kindly see, my lord, what is happened already happened, man. In future, we should be careful. And by this person, because of this person detention, the lordship might see he's the financial power on his hand, my lord. Because of this, his detention, my lord, and there, my lord, project is standstill. It is a public importance. I will come to that, my lord. Before that, my lord, without going to the merits, my lord, I want to place one thing, my lord, before your lordship.
Yeah.
Because your lordship kindly see here in this case, my lord, you cannot blame only the company, man. Your lordship go by the page 54. It is a project, that is a report, monthly report submitted by the disaster management. Page 54, my lord. There is a report on 5/8, 16/8, and 25/8. There are 3 columns your lordship kindly see. So for his 25, the last report that was submitted by my lord disaster management. And if your lordship, my lord, see page 55, my
Yes.
a middle portion, that is my report up to my lord 16/8. In the page 54, middle, in the cycle factory flyover relative barricade has been observed along with flyover as well as in open range in footpath. That is there on my lord 16/8/25, and again on my lord on 25/8/25. Right hand column, my lord, the third column. The cycle factory flyover largely barricade has been found along with the flyover as well as the open range in the footpath. The main concern of the today's inspection is presence of pothole and waterlog. Then, my lord, your lordship kindly see the last page, my lord, page 57. Page 57. Page 57. Yeah, right in color. On the cycle factory flyovers in the center are observed almost entire stage of the fire. Weekly inspection report has been done on 25/8/25. Till 25/8/25, it is there. Everything is, my lord, as per disaster management inspection, everything is there. If, my lord, some antisocial people, they took away the, my lord, cover of the hole, my lord, and took away the bamboo barricade, my lord, then, my lord, it will be very difficult, man. But anyway, even then, my lord, your lordship kindly see, he's already, my lord, in jail. Only 3% of the company is in jail. I am only one, my lord, the director before your lordship, my lord. So my submission before your lordship, another thing is that, my lord, that road is very important because your lordship kindly see that road lead to the Persapara Stadium. Our World Cup is going to be held in the end of this month, my lord. And if the project is stand still, my lord, then it will be very difficult during Puja, because Puja time is a very busy route, my lord. So my submission before your lordship, my lord, at least, my lord, his custodial detention, I think, is not been required because your lord, if I argue on 105, it will be very, my lord, I will take it will be a long time because whether it is culpable in the murder or not, that is, my lord, that will be in the trial, it will be decided now. At present, my lord, I don't think that, my lord, my custodial detention is required for more, my lord.
Case diary has come. Some connected matters are fixed on 19 also.
These are anticipated. There is anticipated.
You will
They are
have to retain the case diary. You will.
There is, my lord, and regular.
This is a BI. I know.
And 3% of the company
If we dispose this off, you have to retain the case diary. We'll need it 19. Or whichever court is dealing with it, we'll need it. Right. So we can some
All possible measure has been taken by the minor authority.
These things keep happening. Responsibility of everyone.
My lord,
Not only the
even my lord,
company, the people who are constructing, they have the direct ground responsibility to maintain. Secondly, the department also cannot escape its responsibility. And they have to ensure that, I have to execute someone, and you have to ensure that I execute it properly. So both of us are responsible.
after all, they are the
I'm doing on the ground, you are supervising overall control. So you have given me the control. I have to do it properly, and you have to ensure that I do it properly.
my lord, if your lordship go by in this case, my lord, even my lord, the parent of the my lord, that they are going to be responsible. When under construction road, my lord, why a 3-year-old boy, parent, why we allow him to be playing in the footpath, my lord?
That all of us should take care. You'll see, you will see people crossing, at very, living in a very risky manner through the road. That is the fault of the person, why is crossing like that. But why, one of the reasons why they cross like that is that there is shortage of road, pedestrian crossings. So they short, both ways. Anyway, we need not digress much. So case diary, you want to submit or you give it to me? Wait once.
And in fact, my lord,
That is
for
there.
they on humanitarian ground, my company has already paid 13 lakhs rupees to the family parent. As they exist.
Only blaming and
Yes, ma'am.
few officials of the company will not solve the problem. It's
My
deeper.
lord.
It's deeper. Give me, I'll pass it. Go through it properly. It's a little set. Result good. Result. So I'll give it in a day or two. Or not, just want to go through it.
My lord.
My chamber.
Diplo.
Senior counsel. Chamber. So, case diary has been received. So, what a order result. Case diary waiting. Give me one day. Yeah, to your attention. Yes, yes. So, 47, would you like to do? Okay. Let us do, I can finish what, would you mind if I take it up after 2? After 2, 2 minutes, second.
Yes, scientifically.
Okay, do you want to, I'll take your submission. You want to submit? Well, do you have to make any submissions? Would you like to make any submissions, sir? Okay, so, okay, I can hear him and please positive. Okay, go ahead.
I'll be here.
TCR received. Charge sheet submitted. What did you say? Okay. He has been indicated as an absconder. We will call for the case. This. So he has come. Mr. Goswami, learned additional people summons that those scan TCR has been received as all for pursuant to submission of charge sheet in this case. Dash seek some time to go through it. Prayer is allowed. List one. You have to next to you, they have to do. Next week, let us space. This the interim bail granted by the order dated 4/8/2025 shall stand extended in the next date of this time. Fixed on 18/9.
We have please of lots of the 482 application, which I am already in the interim protection by order 4825. CDO fall through.
Charge sheet has been submitted.
No, she is computer is
Restoring.
is to where they are. But here also the addition is here.
I've got.
I am the president of the legal.
Mr. Goswami, UP Goswami learned additional people submits today. In the meantime, investigation is completed and charge sheet is submitted. You have the completion of investigation. The interim clear has been granted to the petitioner by order dated 4/8/25 is hereby made absent, subject to the condition that shall be available for trial. One commences. Number two, he shall not hamper or temper evidence. Shall not intimidate or harass the informant or his family. Violation of cancellation of the petition stands allowed and disposed of.
Idea of life.
CD was called for in this case. Protection was given. After the protection, we have appeared and given our statements before the investigating officers.
Investigation has progressed.
Everything you did, say, what's the used against this?
So charge sheet submit.
No, what's that? CD is
So here is it. Yeah.
it's like an entire. Yes, we had a six and recorded.
First four paragraphs.
Mitigation is from making derogatory
Yes.
statements, comments about religious sentiment.
On 4/8/2025, two petitioners were granted interim protection. In this context, learned additional people submits that pursuant thereof, they appeared before the IO and their statements recorded. This it is also submitted. The basis of the received is that the investigation is progressed but not yet complete. The given circumstances, the interim here is still granted to the petitioners. By an order dated 4/8, that is thereby made absolute, subject to the condition that they shall not temporary evidence, they shall not intimidate or harass the informed or his member. The bail petition stands allowed and disposed of on their procedures.
I'm deeply obliged.
Let me go. Well, Lordship, the other day I placed the matter on merit. Lordship may have remembered. So this application first is the anticipatory bail application. Allegation basically is the murder. 103. Conspiracy. And I placed it before your Lordship that in fact the incident is something else. It heavily and on the basis of the report of the Child Welfare Committee that this was a case of suicide, not a case of murder. And therefore, the allegations made in the FIR exaggerated, inflated, and on the very face of it, difficult to believe. Therefore, if we read this FIR along with this CWC report, then it weighed heavily in favor of the presumption that it is very, very doubtful whether the case was the murder, but then there is every possibility of the case being a case of suicide. That being the position, Lordship wanted to see the postmortem report to if there is anything which may suggest.
I think it has come. PM report also is. But in some of the ideal points, and now by IO has also one of his letter, earlier I was considering some complexity in the majority of considering that the IO was also some interesting the accused person, especially allegation, and some the accused persons also trying to specialize the you can go risk the earlier IO was the accused had pressurized police using their might and induce certain functionaries doing the same jurisdiction as it to exercise of his powers under section so has transferred the case to an official in the district to investigate the case in the considering the importance of the type of the nature of the because of that earlier IO will change. So now while you're doing investigation, for the civil accident, only go. Take your submission. You for the inform. You're adopting that submission. Ready for of the bail petition. The FIR was dated 26. 26. 2002. And they reported here in April 27, 6 2020. After the incident, my submission is that they cannot meet this particular. They want to say that this child committee has given you. They want to rely on this committee. And this is what they inside. This is what we do. And they can have very good advice. If they say This is a AB. Yeah, interim is there.
CD was called.
Not interested. Oh, let us wait for the case there. Case diary not yet received. Mr. Chetri. Yes. Some will learn it additional people, some is that case diary not yet received. Should remind them. This Tom, since there is no interim, so let us get it before to a petition. Jordan? Yes. 22:9.
Late, this is your option. My lord, this bail petition, I mean, in fact, since last June, my lord, this bail petition has come at least more than 5 times probably. The issue here is that, my lord, the allegation is primarily 302, my lord, the old IPC 302 and 103 BNS. My lord, may kindly come to the FIR and then, my lord, I'll make my substantial argument.
Let's see that.
The FIR, your lordship will find at page number 8.
Translate
Translated. It's identical.
at 8.
8.
Caused by one Gao program, right?
Yes. Now, my lord, here he says that with due respect, I beg to state it today such as that through a secret source, I came to know that Meena Gogoi, a resident of Kumtai, Nanga, has been keeping a person named Kancha at his residence and was made to work at his illegal liquor production unit. Yesterday on 27/4/25, the above mentioned Kancha had a fight with Meena Gogoi, his son Jiten Gogoi, Moon Gogoi and such and such, who used to work in the same illegal liquor production unit due to some unknown issues, during which they killed Kancha and they dug a pit and buried the body in the jungle across the road in front of their house, according to some secret sources. Today, on 28/4/2025, the accused such as has identified the burial location and led police to the spot, after which the police dug the pit and the body was recovered. And as many as page number 9, 6 persons are being implicated. Now, my lord, I will demonstrate, my lord, from the additional.
Kumtai is in Golaghat.
Yes. Now, my lord, what had happened, my lord? This man who is referred to as Kancha was in fact was their maid since last 13 years. The informant there from the same family.
Domestic help.
Domestic help. And he was suffering from tuberculosis. He died because of tuberculosis, and my lord, this affair is filed only because some people who has some sort of enmity or who are not in a cordial terms, they have wrongly informed, and they also told the Gaonpura that don't take our name. And my lord will kindly see, thereafter when the Gaonpura and the local people realized, they sworn affidavit, which I have annexed in my additional affidavit. If your lordship comes at page number 21, these are all people from the vicinity. Page 21, your lordship will see 10 people. They say at page 22, if your lordship kindly, page 22, they say that Rajan and Kancha are the same person, and para 4, my lord will see, page 22, that Rajan was suffering from serious ailment and was admitted at such and such hospital, Gunabagat, for a long period. That late Rajan died on 27/4/2025 at the residence of Meena Gogoi. This is true. Now, since he belongs to the Mohammedan, I mean, since he was a Muslim
fellow, therefore, my lord, they have buried him according to their own religious rights, my lord. Only because, my lord, of this section, the entire family there, my lord, today someone there, someone here, my lord. And your lordship will again see the informant who is a Gaupura, he has also, when he realized that this the information which he initially received was not correct, he also showed an affidavit at page number 28. I have copies of all these original affidavits, my lord. I can give it to the court master for your lordship perusal.
The Gamburas,
This is the Gaupura.
Gamburas is a page.
Page number 28, if your lordship kindly come.
And it's a 38.
Acha, but my lord, some here and there, information might be there. Yes, 38.
Found it.
38, yes.
Chumakanto Mahato.
Yes, my lord. That is, if your lordship,
Chumakanto.
yes, if your lordship kindly sees page number, the original FIR informant, your lordship will realize that these are the same person. I'll take to the vernacular, the main bail petition, page number 15, if your lordship sees, is the same person. Para 4, 13 years. He was working there. Well, look, a man who is with me for 13 years, why should somebody kill someone, my lord, without any reason or rhyme, my lord? Nobody derives a pleasure in killing a person. And even the postmortem report, because my lord, last time the prosecutions, because when I made a submission that it is because of tuberculosis, the prosecution made a submission that they need the FSL report. Now, my lord, it has been more than 2-3 months probably. The FSL report they could not produce. I do not know whether today they have the FSL report with them or not. Because we are stuck only because of the section.
This one statement in the FIR, does it have any basis in the case that his body was dug out upon showing of one of the accused, Parmokhan?
Was that was full of that the body in the pit of the and there was the body came. So that the body was covered from the pit. And
He was buried there.
Yes,
Buried.
we buried him because he died a natural death in my home because of his tuberculosis. We have buried him. We are saying we know we have buried him because he is a Muslim man. So therefore we cannot cremate him. Therefore we have buried him.
Rajan Gogoi alias Kancha.
Kancha. Because he has to stay with them. They are Gohai surname people. So they have adopted sort of. These are
Adopted
same
name.
person.
Adopted name.
Adopted. Same.
FSL is still awaited, but the injury was antemortem and caused by blunt force impact. Because they are in the hospital. And one of the witnesses,
Blunt force impact.
I was just
a pressure of reddish brown color size 1.5 centimeter and 1 centimeter present over the anterior aspect of knee joint on the left side.
aberrations.
And
that part should be legal. And only one. That's so good. আমি বহুত দিনৰ আগৰ পৰাই দেউতাই কাম কৰাইছিল আনচাই কাম কৰাৰ বাবে প্ৰায় দেউতাৰ মিনাৰবোৰ দেউতাৰ কাজিয়া হোৱা নহয় আৰু ইমান তাৰিখে পুৱা আৰক্ষী আবেদন জানিব পৰা যে কামখন দেউতাকতে সঁচাকে যদি পুলিচ পোৱা কাৰণে ইমান তাৰিখে আৰু দেউতাৰ ঘৰৰ সন্মুখত পুলি কৰিছিল
What? His own son. Statement of his own son. He is also accused of.
No, these are some, and he says, Puna Pao, hearsay. Not informant.
Let me have a look. Accused Jiten Karmakar identified the burial location and led police to the spot.
My lord, there is no,
Is there any statement that he was, his religion required him to be buried?
but because my lord will see, because he is Ali, my lord, Muslim people are buried, man.
No, that's true, but is there any statement?
Yes, I'll show that this is,
These are state, these,
they, this Jiten Gohai
not
and
this, adopted name.
absolutely, my lord, will kindly come to the affidavit shown by the informant itself. I'll show from there that he Kancha and they are same person. Para 4, Rajan alias Kancha, and the medical report will show his name as Kancha Ali. That he was suffering from other diseases. We have annexed his medical page number, if your lordship see, page number 31, annexure C of the additional affidavit. Name of the patient Kancha Ali. The second page, page 32, Rajan Gogoi alias Kancha.
Kanchas are usually used for Nepali people.
Absolutely, my lord.
Huh? Jiten Karmakar himself is an accused. Statement is.
And my lord, I was just contemplating, if 6 people have killed 1 man, there would have been multiple injuries.
Until get to be clarified, why they, without informing anybody, the local people, why they write the death certificate?
Where is the postmortem?
Postmortem report, my lord.
They are part.
It's not a regular bail, it's anticipatory. They'll get one year.
The allegation and the postmortem report does not remotely tell him. These are all hearsay, Hunisu, secret. So this sort of statement, my lord.
They are from the same locality, my lord. They can, as and when called for, they can go, my lord. So, any cooperation required from their end, my lord.
Third. The petitioners hearing are seeking anticipatory bail in connection with the petitioners. How many petitioners? One petitioner.
And for the accused number 3.
Motor over this means seeking anticipatory bail in connection with Omorgaon PS case number 19 of 2025 under section so and so. The allegation in the Azahar dated 28/4/2025 is that one person named Kancha was kept in the house of one Meena Gogoi for working at illegal liquor production. And that on 27/4/2025. There was, for some unknown reasons, the said person named Kancha was killed and his body buried in a jungle across the road. It is further alleged that on the next day, that is 28/4/25, upon being identified by Jiten Karmakar, the body was dug out by the police. These 6 accused persons have been named in the FIR. Including the present petitioner name. He is not named.
No, he's there, his alias name is there, Moon Gogoi. Actually, he is Hemanta Gogoi.
Moon. Has been including the petitioner named as Moon Gogoi in the FIR. The learned counsel for the petitioner has drawn my attention to an affidavit made by the informant stating that the deceased was working as a domestic help last 13 years in the house of Meena Gogoi. And he was suffering from serious ailments and died pursuant to the illness in the residence of the accused. Several villagers have also filed an affidavit on similar lines. The case diary as called for has been received. The investigating officer has made a noting opposing the bail. As per the contention to the petitioner side, the deceased stated to have died of tuberculosis, which he was suffering from for a long time. In the postmortem report, final opinion regarding death is kept pending till receipt of chemical analysis report. But as regards the injuries, it is stated that the injury was ante-mortem and caused by blunt force injury. I have also perused the statement of Jiten Karmakar and what is the other son named Tuleswar Gogoi. He's not a son, one Tuleswar Gogoi. The learned counsel for the petitioner submits that the deceased had died of illness, and as he was Muslim by religion, the family members of the accused buried him. However, I found that to be contrary to the finding in the postmortem report. There are also no sufficient materials to indicate that sufficient materials in the petition or otherwise to indicate that He was indeed a Muslim by religion. Despite the affidavits filed by the informant and some villagers, the contentions of the petitioner side were not found to be convincing to the court prima facie. This being a investigation is in progress, this being a anticipatory bill. I am of the considered view that it would not be prudent to grant anticipatory bill in view of the immersed materials. Accordingly, the bail petition stands rejected, return back the case done.
Madam, since your lordship has observed that there is no material to indicate that he is a Mohammedan, my lord,
There is no sufficient.
my lord, subject to what your lordship says, my lord, it is just by submission.
Correct.
Can it be this way, my lord, that since I'm not on interim protection, can the police file a report to the PP to identify his religion? Because, my lord, I am told categorically that he's a Muslim.
No, there is no statement in your petition nor in your additional effect. Forget the affidavit filed by them. But you got antemortem and blunt force impact.
And
That
these are
cannot
in
be
the-
overcome.
they say in the-
Completely different from natural death.
Knee, in the knee portion they say, because the postmortem report,
Antemortem and blunt force impact.
in the knee portion, my lord, when the knee portion is,
And
if your lordship just keeps it subject to what your lordship says, that one,
there's
my
no
lord, one opportunity to the police that,
No.
let the police and file.
there's no sufficient materials. I do not find sufficient materials to indicate that. Even if it is that, as the learned additional PPS said, the act of burial also appears to be surreptitious. So anyway, if it is regular bail, the matter would have been slightly different. Anticipatory bail, that too is of a person who appears to be guardianless, seems to be. Anyway.
I'm obliged.
Never mind. Not near the sufficient details. I do not find sufficient details. Indicate the religion of the petition, religion of the deceased required him to be buried. Thirty?
54. Yeah, please, Ross. CD was solved for on the last of Yeah, I was lost, my lord, I have registered for 3 sections, my lord. All the sections are available sections. My lord.
What is the allegation?
My lord, allegations, my lord. The petitioner, my lord, the cultivator, my lord, the petitioner.
Marpit case.
Marpit case. My lord, sections, my lord, implicated, my lord, here, my lord, all the available sections.
Any serious injury?
There is no signature, or rather, my lord, my lord, petitioner, I have 3 stitches, my lord, in the head, my lord. Yes, I am apprehended. My lord, FIR lost on, incident happened on 9/8/2025. FIR lost on, my lord, 3/30/2025. And FIR is registered on, my lord, 2/9, my lord. So, my lord,
After 1 month.
after 1 month, my lord.
Anyway.
And all the sections is bailable sections, my lord. I am fairly certain.
Except. All the sections are.
Bailable, bailable.
No, there must be some non-bailable sections.
No, my lord, no. My lord, 126(2) is wrongful restraint, my lord. It is bailable. 117(2), my lord, voluntarily causing grievous hurt. It is also bailable, my lord. 351(2), my lord, criminal intimidation. It is also bailable, my lord.
Then anticipatory. All are bailable, my lord. No, if all offenses are bailable, then the basis of anticipatory bail is not there.
But I am apprehending, my lord.
Bailable offense.
Yes. Allowed to appear before the IO. I am ready to cooperate, my lord.
I'll also cross-check if necessary. The sections. I've not written this. Can you help me with the sections? Tell me that section. Or do. No, there's the case law also. In case of bailable offense, anticipatory bail does not lie. Because you are entitled to pay.
My lord.
Suppose it might be different matter where they may, they file a charge sheet including one bailable section. Then you may have.
Then
other
that will
section.
come.
You can file a expressive, but as of now.
I something
I don't know.
at this stage I may be allowed to appear before the policeman, cooperate with the investigation.
So that's why help me with the sections where it is there.
And section is 126 2.
Let us go to the FIR. There in the FIR. Eight. Resolution.
Like if I not, I have annexed the, my lord, medical.
Procedures are basically there in the city. I'll quickly tell you.
Smile. And before your lawsuits on apprehending, my lord, subsequently your lawsuits was pleased to call for the.
This one. Investigation going on. Right? Yes, okay, Pokemon space case number. Okay.
Pokemon space case, my lord.
5920.
Yes.
126. 117.
51 2. 1351 2.
Satisfaction. From the schedule. One 117.2 is voluntarily causing grievous one, that is bailable.
Yes.
126.
But wrongfully restraining
Wrongfully restraining.
any person.
So bailable. 351.
351 2. Criminal intimidation, my lord. Also, my lord.
Criminal. The case diary as called for has been received. The medical report available in the case diary indicates assault by spade, green packet Kodal, blunt side, Kodal's dash blunt side, and the injury has been labeled as simple. The case which has been registered is Fakirgan's PS case number 89 of 25 under section 126(2)/117(2) 351(2) PNS. The said offences dash voluntarily causing grievous hurt semicolon. Another one is wrongful restraint semicolon. Criminal intimidation, so it's attached to it, are all bailable offences. Stop. In view of the fact that all the offences registered, all the offences under which the case has been registered against the petitioner are bailable. Dash the foundational requirement for maintainability of anticipatory bail not there, and therefore this petition failed to be non-maintainable. However, the petitioners shall appear before the investigating officer for by way of cooperating with the investigation. That will be. Don't worry. The instant appearance bill applications, then disposed to one person. You appear and therefore they'll grant it.
Subsequently, I came, my lord, FIR was registered under non-bailable. At the time of filing, my lord, I have not annexed because, my lord, only upon appealing, no possible.
Suppose this is possible. Suppose there's some development and they file under non-bailable section in the charge sheet, then that will be a fresh qualification. Right. The moment they do.
Some protection.
Not necessary, actually. Not necessary. You'll understand. I've indicated. All bailable, so it's not necessary. They will appear and they will go on bail, automatic, as a right.
Yes, ma'am.
As a right.
That may be reported in the loss.
As a right. No, not necessary. Appear before the IO for by way of cooperating with the investigation. That will.
Hello, guys.
28, 90.
Yes, I have all the sections are available. Thoroughly cooperated that.
But if this matter, our largest collection is we got to start from these are legs in another court.
Is it? This is item
Item
left on. Wait, bails are open. Those bails are open.
for some time.
39 is coming. Order it. 38. Adjourn. After some time. we'll check. 39.
Last operation, we have taken steps about the responsible complainant, but 1 month's already passed to worship. So he has not come today, the worship, and there is a condemnation petition that is 295 delay matter. Another is we have also filed one other miscase that is for bail petition. The conviction is 6 month lordship, and the petitioner is undergoing more than 4 months in the jail custody. Lordship.
Oh, now I remember. So this needs to be disposed of. Otherwise, the NI.
NI Act.
The appearance is not necessary. When the steps is has to be. There is no updated office note also. Apart from 11.9. Service is not complete.
Lordship already steps was taken in 1 month already passed to lordship. Service may be deemed lordship.
Office note says that notice upon response to by registrar postal AD will receive back unserved insufficient evidence. Other file, look also. Please have a look.
Whatever address given in the is that address we have given.
No, if not, no ID comes, then we can access it. Under 27, we can deem to listen. But your export return back with insufficient address. Because the problem is, otherwise there's no problem, but he's in custody. Then I cannot go into the revision without this, right? How many days of delay?
290 days.
Insufficient address. Corona Textiles. Fancy person. Would you like to serve Dusty? These are the only two options we have. Presumption, which is not possible because of insufficient evidence. Otherwise, I could have done presumption. number two, dusty or newspaper publication. But if seeing the fancy for the address, I thought of this. Dusty, don't, if indeed this address is correct, then dusty will be possible. But very short, dusty by hand. Try it. Otherwise, if you do not find the address, then newspaper publication. Then we have to complete the process. Even if delay is slightly on higher side, but still, since it's a criminal matter, though the petitioner side had taken steps by registered AD upon respondent number 2 complaint, but as per office note dated 11/9, it came back unsolved with remarks regarding insufficient address. The address is indicated as located in Fancy Bazaar area of Guwahati. It is submitted that the instant application is a delay condonation petition. And the applicant petitioner who's filed this revision against congruent findings of guilt under NI Act is already undergoing the sentence. It will be injustice if we cannot meet quickly. At least we should. Because his 4 months, what will be left of revision? It will be infructuous. In the situation, the applicant petitioner side shall take steps upon our respondent number 2 by dusty service and submit affidavit documents. Even if it is not there, you may get some clue as to where they are. Otherwise, newspaper will quickly 2 days and finish it. You tell me as fast as you can. Friday, you quickly take the service, file there. List on 1990 in the orders form. No more orders.
I think senior counsel, Mr. K. N. Chaudhary is engaged in this matter. Is that lax? Better be taken after some time.
Just a minute. Okay, no problem. No issue. In this case, any CD has been received. This matter, which was adjourned time, washing of FIR, Bureau of Economic Offences, registered by Bureau of Economic Offences against a company, I believe. Since it is FIR, there last year submission, a different court, submitted charge sheet. This charge sheet. When we made this, thereafter it was listed. Charge sheet has been sent. They may have to modify their prayer also. Wash the charge sheet. But in that case, CD and CS would be necessary, isn't it? Not fine. Let's see. Senior counsel. Criminal appeal.
No, Lordship, it is an appeal against order passed by the learned additional section. I take your Lordship to include order page 14 and the operative person of the order at page 15. Lordship. Right.
Given order pay.
Such and such to pay penalty of ₹1 lakh. I am aggrieved by the amount, Lordship. Bail bond amount is 20,000, Lordship.
Bail bond amount is 20,000.
20,000. Lordship, kindly, I have annexed the affidavit that is at page 20.
Just a minute. Only the state is implicated, right?
Lordship.
No private respondent.
No,
No private respondent. Yeah, which page?
page 29, annexure 4. It is a type copy and photocopy at page 30, Lordship.
Page 30.
Lordship. Property value 1 lakh and bail bond amount 20,000. We aggrieved by
This. The penalty would be equivalent to the bond.
Lordship.
What's
Bail bond amount at first should be forfeited and then penalties to be imposed upon. But here it whole property is.
Oh, first, no. Your submission. Bail bond amount is forfeited. Then apart from that, there can be penalty. It might not withdraw as a COT. Something. But where you will withdraw. Confidence itself. Sometimes may not matter the property. Imposition of the penalty is optional. It's optional. Record the grounds of such proof and call upon pay the penalty thereof. Forfeiture of the bond itself is penalty, or according to you it is extra?
No, Lordship, it should be at first bond amount is to be forfeited. Lordship, kindly have a look at section 446. And then the penalty is to upon it, penalty should be imposed. But here whole
After the bond
whole
is forfeited,
Lordship.
it is compulsory to impose penalty.
But
that is
if he pays, then there is a penalty. The question of penalty does not.
No. If the bond is say 10,000, 10,000 is paid.
Then no other Lordship penalty.
No penalty.
If he paid, there is no penalty. Otherwise, he paid to.
If he does not pay, then penalty.
Then then process it to.
which may be more than the bail amount. But in other words, if I've understood correctly, you are, here the bail bond was of 20,000.
Not.
So he did not pay.
Lordship, he did not pay because here Landed Court at the very first day imposed a penalty of 1 lakh. That's, but time was given.
He has to
To
be,
show-
he has to be given an opportunity to show cause also.
A lot.
That was done.
Time given, but in the meantime, we have approved this honorable court for. So Lordship, at this stage, notice may issue and proceeding may be stayed.
That can always be done, but. Slightly getting this part. 20,000 is forfeited and thereafter the court can impose a penalty extra. Extra, right? But in this case, that means he's agreed by the proportion. The whole property has been imposed as a penalty. Whole property. Am I right? Correct me. I may be wrong.
order.
Huh? Huh?
In the petition, we have only one order.
Yes.
So that is available with us, man of the order at the 29/7/2025. That is man of page 14, man of annex 1.
Okay, let me have a look at this. Some elaboration in the NPU note.
Yes, sir.
Forfeit plus penalty.
Yes.
And that's why it's agreed by the proportion.
The potential is there, that's why this order, madam, that madam. Was madam, is taken to the trailer, but madam, within the, madam, there is the base code in the, madam, the bottom, madam, the trailer appearing in the base code for 18.
Yes, I go and that and all.
Yes. And madam, the next part is only that, madam, this compensation is that therefore we find it fit to forfeit the bail when executed by bailiff so and so. Or accused so and so on so in such and such state. The deal that madam, submission is that okay, but madam, we therefore find it to be ask the bailiff to pay penalty. So the forfeit the property is because not is okay, but madam immediately madam imposing that part.
Yeah, no, forfeit the bond, that's okay.
That's their submission. The
but the
raised
third-
part is the 1 lakh amount, my lord. Is the penalty, my lord.
That
Not
means
the
it is
sum.
1,20,000.
Yes. That amount that is there.
That prima facie looks a bit disproportionate.
My, because if my lord, before that, my lord, some orders are there, but on that order reading, this
Yeah.
order, my lord, nothing will come out. Only that is the understanding with the on the same day this part. If my lord, some connected orders are there because it was from long back, my lord, that is pending. That is also stated in the my lord.
Yes, he may be justified in forfeiting the.
Maybe, but
That
my
is
lord,
because he has been.
if my lord, the repeated email of that part is there,
Uh-huh.
and already my lord, the forfeit amount is there in earlier orders. Then subsequently in this order, my lord, that in respect of that forfeit property, if he appears and make that statement, that the accused will be appear. And on that part, if it is the penalty imposed, then, but from the going through this only this single order, my lord, is difficult to understand. From there only we can understand it immediately, my lord, the same day, that is the, along with the forfeited amount, this, my lord, additional, that is the penalty is in. But it's a long case, madam, so other orders, you can only say, madam, whether they are in the list part.
The PMA. Should we call for this thing? Or dispose it of? Or try to dispose it of? But if sufficient materials are not here then for disposing, then that's the thing. Otherwise, this matters. You are willing to pay the bond amount?
Because in the prayer it is categorically listed. The prayer is on page 9 by. It's 9 by law.
That must be also, that, you make a bond, and if I am unable to fulfill, then the bond goes.
Penalty amount on the section saying so a reasonable sum, considering the financial.
Where? Oh, his petition.
Yes, this
Where? Which one?
is part of the page 9, no? Page 9 prayer. Alternative. Remit the penalty amount of the section. Reasonable sum, considering the financial condition of the development and cause of the
Property value is given because that is to see that it covers the bond amount.
Yes,
The bond amount should be within the property value.
yes.
I signed a bond of 10 lakhs. Suppose and I have a property of 5 lakhs. So that will not be there. It has to be covered. So that's the thing. Should I dispose it?
Not,
Should dispose it?
you tell lordship, bond amount
And a little extra. That is the.
that may.
LR Mazumdar, Learned Counsel for the appellant. Please sit down. If I can. Learned Counsel for the appellant. And K. Boyso, Learned Additional BP. For the state of Assam. / prosecution, which is the sole responsibility. This is an appeal preferred by the appellant Abdul MD Abdul Mutli. And the section, it will be a BNSS or CRPC. While in 25 BNSS. 495 of the BNSS. 95 within bracket corresponding to earlier 449 of the CRPC 1978. Against the order dated 29/7/2025 passed by the learned additional session judge Ojai in criminal miss number 10 of 2022. Whereby the appellant who was a bailer for the accused was imposed with a penalty of ₹1 lakh under section 446. Corresponding section. So, when a judge in the order, you have filed a criminal petition earlier. That was. Under section so and so, BNSS. The learned counsel has drawn my attention to the order, the impugn order. Annexed as Annexa 1. The order dated 29/7/2025. It is stated that due to non-appearance, proclamation had to be issued with regard to accused Srishti Ranjan Bhumik, who was eventually declared an absconder and warrant of arrest kept pending the concerned police station as per due procedure. Thereafter, a miscellaneous proceeding was initiated against the appellant / bailer under 446 CRPC, BNSS. Despite elapse of several dates, the appellant bailer could not produce the accused person. And on 29/7/2025, he sought some more time, which however was refused. And the learned additional session judge was pleased to direct that the bail bond would be forfeited, and also directed the appellant bailer to pay a penalty of ₹1 lakh, feeling which other course of action would be initiated under 446(2) CRPC, .BNS. The learned counsel drawing my attention to a copy of the bail bond, submits that the amount of the bond was ₹20,000 and the estimated value of the property was ₹1 lakh. In this backdrop, the appellant is aggrieved by the fact that apart from the forfeiture of the bond of ₹20,000, he is being imposed with a penalty which is equivalent to the entire value of the property. Under the provisions of section 440 ARPC.PNS is replacement. Sorry, 446. When a bond is forfeited, the court shall record the grounds of such proof and call upon the person bound by such bond to pay the penalty thereof, or show cause as to why it should not be paid. The relevant extract may be reproduced herein below. 446. Subsection. The same section 446 may be reproduced here in the heading. So, next paragraph. What should I record as your submission? Also heard clear questions, additional people. Who submits that? I'm taking your submission. Yes. Sometimes we have to. Who submit that as the appellant as bailer failed to produce the accused, who had to be declared an absconder or claimed absconder. It will be justified in law to forfeit this bond. Next paragraph. I've perused the materials and considered the submissions of the learned counsel. I find some force in the contention of the learned counsel for the appellant that the impugn order straightaway imposed the penalty of ₹1 lakh. Stop. Upon giving a fresh look to the statutory provision as reproduced above, I find that if proof of forfeiture is recorded by the learned court, the concerned person slash bailer shall be called upon to pay the penalty thereof or show cause as to what should not be paid. In this case, there is no doubt from the materials that the appellant who had stood as bailer from the for the absconding accused could not produce him, and therefore is liable to forfeit the bond of rupees 20,000. However, imposing a penalty to the extent of rupees 1 lakh dash, which is equivalent to the entire value of the property mentioned in the bail bond. Dash is, to my mind, disproportionate, and should be interfered with in this appeal. You need to write much actually. You pay the bail bond amount. Yes. Okay, when it was, right? Accordingly, the impugned order dated 29/7/2025 passed by a learned additional session judge to Vojai, criminal miss within bracket B 10 of 22 is hereby set aside and quashed. The in view of the failure of the appellant bailer to produce the accused, his bail bond stands forfeited and he shall pay an amount of rupees. He shall pay by way of penalty an amount equivalent to an amount of rupees 20,000, which is the value of the bail bond. Okay, 20,000. What else should I write? Should you give a date?
Oh, on the lordship, it may be within 1 month.
The said payment may be made before the learned court below within a period of 1 month, the date of this order. The appeal stands allowed and disposed of. Allowed, actually, it is partly allowed. Actually, partly allowed.
This order may be no, or my lord, let's say this. But only the amount that is the part of the penalty. That is for the 1 lakh, that is.
That's actually it's modification.
The other is
Modification.
This part is same. Only there is the value is now come to that, there is the bail bond amount 20,000.
The impugned order requires to be interfered with and modified. Then last one, instant criminal appeal is disposed of on the aforesaid terms regarding modification of the amount.
All right.
To within 1 month. Huh?
My lord, I am appearing item number 15, my lord. My lord, my friend is appearing 16, 17. He is more acquainted than this. I will first, I would guess.
These are connected.
Connected. Lordship may kindly take up item number 17 first. Everything will be clear. Here, Lordship, these 3 petitions are arising out of same FIR.
Just a minute.
Yes, Lordship.
Who stapler wasn't stapler? It is.
Lordship, these 3 petitions are arising out of same FIR, but Lordship, 3 cases are filed differently. Because Lordship, item number 17, these are main accused, these persons are on bail, and in other items, 15 and 16, there are total 5 numbers of petitioners. They are on interim bail, interim protection. And interim protection was granted by this honorable court after perusing the case diary, Lordship. Now, Lordship may kindly firstly take up item number 17, where the main accused is here. Lordship may firstly come to the page number 58, the FIR first. Firstly, Lordship, the FIR first.
17. Item 17.
Yes, Lordship. Item number 17, page number 58, Lordship. Page number 58. May I read, Lordship? অপৰপক্ষৰ নাম যোগেশ বৰুৱা ধনকন মূল অভিযুক্ত উইদিন ব্ৰেকেট মূল অভিযুক্ত দিছ ইজ দ্য জিষ্ট অফ দ্য কেছ মাই লৰ্ড বিষ্ণু চেতিয়া মঞ্জু গগৈ নৱনীতা গগৈ সৰোজ গগৈ so and so total 18 persons are named in the FIR lordship total 18 persons are named in the FIR মহোদয় সন্মানপূৰ্বক বিনীত নিবেদন এই যে ওপৰ উল্লেখিত অপপক্ষই মৃত বনমালী ভূত প্ৰধান শিক্ষক আচাৰ্য শংকৰদেৱ শিশু নিকেতন ঢুকুৱাখানা অসৎ মানসিকতাৰ চৰিত্ৰহীন আখ্যা প্ৰদান কৰি সমাজৰ ওচৰত হেয় প্ৰতিপন্ন কৰি বিদ্যালয়ৰ পৰা আঁতৰোৱা এটা অসৎ উপায় অৱলম্বন কৰি গোহাৰি ছপা কৰি বিদ্যালয়ৰ লগত জড়িত নাগৰিক ঢুকুৱাখানাৰ অতি ঘৰে ঘৰে গৈ গোহাৰি বিতৰণ কৰি ভুৱা অপপ্ৰচাৰ চলোৱাৰ লগতে বিভিন্ন স্থানত বেনাৰ পোষ্টাৰ লগাই মানসিকভাৱে অত্যাচাৰ চলায় যিহেতু মৃত বনমালী ভূত সৎ প্ৰকৃতিৰ লোক আছিল তেখেতে এনে কাৰ্যত জড়িত নহয় গোহাৰিত উল্লেখিত আহ্বায়ক মণ্ডলীৰ পৰা পোৱা মানসিক অত্যাচাৰ সহ্য কৰিব নোৱাৰি 1 মাহৰ বাবে বিদ্যালয়ৰ পৰা ছুটী লৈ ঘৰত আছিল ইয়াৰ পাছতো অপপক্ষগণে ক্ষান্ত নাথাকি 28/12/2024 পুনৰ এখন ৰাজহুৱা সভা আহ্বান কৰি মৃতকক পুনৰ অপদস্থ কৰিব বিচাৰিছিল লগতে ঘৰলৈ আহি সভাত উপস্থিত নাথাকিলে কথা বেয়া হ'ব বুলি ধমকি প্ৰদান কৰিছিল ফলস্বৰূপে তেওঁলোকৰ মানসিক অত্যাচাৰ সহ্য কৰিব নোৱাৰি বনমালী ভূতে আত্মহত্যা পথ বাছি ল'লে দিছ ইজ দ্য FIR now lordship from annexure 1 to 6 I have annexed all the documents regarding his corruption and his illicit relation everything is there lordship since 2022 lordship for last 3 years these allegations are in public domain that there are severe types of corruption and he has had a illicit relation with a lady teacher in that school and he got red-handed on several occasions. These documents are very much clear. Now, lordship, after when these persons hold a public meeting, thereafter he committed suicide and his wife lost this FIR. This is the case, my lord. Now, lordship, here what happened? This item number 17, these 3 petitioners, the first মূল accused, মূল অভিযুক্ত যোগেশ বৰুৱা, his father established that school. That school was established by the father of Mr. Yogesh Buru, the main petitioner in item number 17. And lordship, he had an emotion with that school and he couldn't bear his corruptions and other allegations. Thereafter, what happened? At his initiative, other 2 co-accused in this item number 17, total 3 persons, they conducted and arranged the meeting. Meeting was arranged and they 18 persons are named. They all are reputed persons, lordship, retired headmaster, teacher, all are reputed. They are invited to that meeting. And accordingly, item number 15 and 16, these petitioners attended that meeting. Suppose allegation is that in that meeting, something deliberately, intentionally, they said something against that deceased person. Lordship, what is the guilt? Where is the guilt? Where is the abatement? Who had attended that meeting? And lordship, in the FIR, it is alleged that they are holding meeting and it is also said in the FIR that he is not involved in such, but lordship, we have documents here and every document speaks about everything. Now, lordship, what happened? When search sheet filed, 50% people's name is not there. Only 9 persons' name are included. Names have been included in the search sheet. Now, lordship may peruse the search sheet. Yes, page number 79. Page number 79. Lordship.
Give me 2 minutes.
Yes, lordship.
Let me just see something in the.
Yes, lordship.
Okay. Page number?
Yes, Lordship may kindly peruse the vital document, the search sheet, page number 79, Lordship. 17. It starts from page 68 and Annex 11, but Lordship, relevant portion is at 79. May I read, Lordship? Please. Second para, Lordship. No, I should read first from the beginning. During the course of investigation, visited the PO, and inquest over the dead body is conducted by executive magistrate, send the dead body for postmortem examination in the Lakhimpur Medical College and Hospital at Lakhimpur, have drawn rough sketch map of the place of occurrence, arrested the following accused persons, and recorded the statements of witnesses who are acquainted with the facts and circumstances of the case, and also seized the relevant materials in presence of independent witnesses by videography. It was revealed during investigation by various witnesses is that deceased person innocently being targeted by a group of people, accused persons within bracket, for a long time, started in the year 2023. They tried to prove his incompetence for the post of Pradhan Acharya by bringing allegation like illegal affair with his female colleague and financial frauds. SS Sankardev Sishu Niketan Dhokwakhana, financial funds. They never took any legal action but defamed him publicly by spreading the rumors. Here I have to say something about it. It is said in the FIR that we have not taken legal action. What legal action the guardians of the students of that school will take? They write several letters, and these letters I have an annex from Annex 1 to Annex 6. These are the vital documents. I have already annexed. They have taken steps, but now Sarsit is saying that we have not taken legal action. What legal action we will take as a guardian against the headmaster? Only we can file representation, and Lordship, we can hold meeting. These are done. Now, Lordship, thereafter, at last, when the disease anomaly suit was in leave under mental stress from 4/12/2024, this is vital, Lordship. From 4/12/2024, the accused persons conducted an open meeting by inviting guardians and well-wishers of Dhokwakhana Sankardeva Sishu Niketan. And Lordship, item number 15 and 16, they are well-wishers of that Dhokwakhana Sishu Niketan. It is noted that they are denied when they are trying to conduct the meeting at the venue at Sankardev Sishu Niketan. But the accused persons were so determined to publicly defend and dethrone Banamali Sud from the post of Pradhan Acharya. The accused persons distributed pamphlet within bracket Buhari regarding arrangement of meeting to be held on 22/12/2025 at 11:30 AM to guardians as well as students of Sishu Niketan Dhokwakhana. They also make and display a banner hoarding in the public mentioning the financial fraud and illicit relationship of deceased Banamali Sud with one his female colleague. After that meeting, the accused persons were repeating, preparing for second open meeting to expose the Banamali Sud. So the deceased person had only one option left for him, that he choose according to some witness. The whole process adopted by the accused person is found to be intentional and definitely abetment for the suicide of the deceased person. Accordingly, after having sufficient evidence against the accused persons, three of them, namely Jugesh Borua, Nabo Kumar, and Pioram Kupon, are arrested and sent to judicial custody, and the other accused persons were appeared before the police along with PRS bail, and hence was released on executing bail bonds by having suitable bailor and recorded their statements among to the accused persons. Now, Lordship, here Sarsit is saying that if their conduct amounts to abetment of suicide. Now, Lordship, Lordship may kindly peruse this Supreme Court judgment, what may amount to abatement of suicide. Paragraph number 40.
Shiva,
Which paragraph number 40, Lordship may kindly, recent judgment. If there is not any all paragraphs are relevant in this case, Lordship. They are totally
This is more
similar,
recent.
but Lordship may kindly
More
peruse
recent.
only 40. The last,
this is more recent.
more recent.
Since we have judgment is there. But in this year or where also. Second week. Anyway. So where should we complete the charge sheet? No?
Yes, Lordship. Yeah, it is further, there are witnesses and other things. Now, Lordship,
Charge sheet has been filed against 5.
no, Lordship, to tell, I'm sorry, to tell 18 persons are named in the FIR. In the search sheet, 9 persons are named. 9 persons are named in the search sheet. Here, Lordship, the main accused, this item number 17, 3 persons who conducted the meeting.
They are in the other two petitions.
In the search sheet is written, they
In the other two criminal petitions, people are also charged sheet.
also search sheet, but Lordship,
And,
they have.
and the 3 persons represented by you are also charged sheet.
Yes, Lordship. Lordship, what happened? This item number 17 is separate only on the ground that they organized the meeting. They all other persons attended the meeting, and the persons appearing in item number 15 and 16, Lordship, they just attended in the meeting. Neither they have printed any pamphlet, they have distributed Buhari, nothing. They just attend. Lordship, I want to give an example. Suppose, Lordship, I am a member of the Guwahati High Court Bar Association. I have committed something wrong, and a meeting was held in the High Court office by the Bar Association. And they took some reasoning against me, and I have committed something. And all the members attended in that meeting, High Court Bar, they may be arrested. Is it possible, my lord? And Lordship, why they are holding meeting? They are holding meeting because against that person's Lordship, against that headmaster, Lordship, there are several types of allegations. Lordship may kindly peruse Annexure 1 to 6. This annexure speaks that he is involved in, and they attempted to dethrone him for the reputation of the school. And Lordship, he has committed suicide. And now, Lordship, those persons, Lordship, retired headmaster, teacher, and all are reputed persons. In Dhokwa, Lordship knows that Sato Bihu, and they are also member of that Bihu, or known by all Assam. And reputed persons, all are. And now, Lordship, for attending that meeting organized by the son of the founder principal of that school. And Lordship, Jugesh Borua, he is the, why he has holding meeting, he had some, I have already spoken, Lordship, his father established that school, and Lordship, he had an emotion with that school, and his wards are also studying in that school. His own son is also studying in that school. Lordship, today, Lordship, this case is fixed for stay, Lordship. Now, Lordship, on 18th, in trial court, this case is day after tomorrow, on 18th, this case is fixed, and other persons in 15 and 16 who are in anticipatory bail, they have taken adjournment for 2 days. And Lordship, on last occasion, it is directed that they must appear before that learned trial court. So, Lordship, the case is here today. I most humbly request your Lordship to grant protection to the petitions.
And look into that aspect. I thought you were trying to dispose.
This way, your
disposal.
your
But I
Lordship
don't
may,
know whether time will permit. Anyway,
your Lordship may also
we'll see
dispose of.
at the end of the this thing. Should I go to the prosecutor?
Yes,
And
yes.
there's one problem, however, I think, because we have to hear the inform. Right? She has been implemented. So steps have been taken, because otherwise.
Steps taken,
Otherwise,
Lordship, it is served It is served, it is also duly served. Most probably the informant will not appear to my information because before the death of her husband, for last 3 years, she had no connection with his husband because of that illicit relationship. But Lordship, I had not to say this, not to my information. He is living separately from his wife due to his illicit relation for last 3 years. And now she is filed FIR. So, it's-
Registered post with AD was taken on the right address.
yes, Lordship, through OC, it was served. Through OC, second time it was served. First time it was not, it was served, but the AD card was not returned. Thereafter,
Help me with, sir,
thereafter it was directed to take step through OC
still address.
and it was served.
I'm not, of course, I accept what you're submitting, but I'm just duty checking it. I registered it with the same address as the post title.
Lordship, may kindly peruse item number 735. This is the leading case.
Which the case law.
Item 15 is the leading case, 735, criminal petition.
50. Here,
Yes, that may be perused.
here there is some endorsement. It was sent at the same address as the
Yes,
post title.
yes, and it was duly served. It is there.
Oh, it has been served.
Served. It is served, Lordship.
Not worried. I
You
thought we have to draw presumption
Yes.
of service. Like this. No problem. then. Like X. So this problem is solved. Mr. Lordship. But here it is not reflected. In this it is not reflected. In this it is served.
3 cases are same, Lordship. It may be presumed that in one case, if she this is the motive, it will amount to acceptance of
That's
all the cases.
In the other. The rest too, we can draw presumption.
Yes, Lordship, because arising out of same FIR, Lordship.
16. So now, so that part is not a problem. So.
Regarding some recent school pass. Regarding.
Just a minute, please. So you have to received that. In one, it is sent, it is mentioned in office note, mentions in this 748 that it was sent by registered AD but not received by. One is service report has come properly. Service report here. It said that it has not come back. What is it? But it was sent through district ministry. It was sent through district ministry. One service report, it has been served, one, in one case. In one case, so it is mentioned that it is sent with registered AD it's registered AD and nothing has been received back. So in that case, we can draw presumption, but here, it was sent to district magistrate. In this case, is 666. Who's there? You're there. Six.
No, Lordship,
In 666, it is,
only one petitioner is there. It was filed at the very beginning.
it has not mentioned that it was sent by registered AD. It's not mentioned. It is mentioned in the note that it was sent to district magistrate. I'm trying to see whether presumption can be drawn.
Lordship, presumption may be drawn because PS 735 is leading. So after filing of other two cases, 735 was leading, and Lordship, in that case, she has received the notice. So Lordship, presumption may be drawn because arising out of same FIR, case is same, and only petitioner's names are separate. Otherwise, all things are same. Three cases.
Procedure will be
Presumption may be drawn.
sensitive matter, otherwise. Of course. You can have a look if you can have a look and guide me. But anyway, so in that case, if you are not trying to dispose of, then we can admit it. Then consider the prayer for stay and decide.
Yes, Lordship.
You have a look. Please have a look here and guide that board.
Yes, my prayer is also there, Lordship. My prayer is also there. Then let her give some time. If she wants to come before the court, yes, she can. Thereafter, these cases may be disposed of finally. But Lordship, as these reputed persons are now they are in trouble only because of they have attended the meeting. So I am praying for stay.
Criminal petition 748 of 2021. Indicate for item 17. Saji Somo, learned counsel, and DP Goswami, learned. You are in the other petition. Okay. Don't worry. DP Goswami, learned additional PP for the state. The three petitioners herein have been charged sheeted for the offense of abetment of suicide, the informant's husband, in connection with Okwakhana PS case number 114 of 2024. The prosecution appears for the state. The informant is respondent number 2. As per office note dated 6/9/25, notice has been issued to respondent number 2 by registered post with AD on 8/7/2025. But no unserved notice or AD card has come back. In this context, it is submitted by the learned counsel that notice was issued upon the proper address of the informant appearing in the cause diary. Therefore, notice upon respondent number 2/informant is deemed to be complete in exercise of powers under section 27 of the General Clauses Act. General Clauses Act. What did we call for? Scan copy of? It has been received. We'll need the CD and charge sheet.
Yes,
It is available. The scan, it appears that the scan records as called for has been received. Upon perusing the materials and considering the submissions of the learned counsel for the petitioners, I'm of the considered view that that there are materials on the basis of which it would be worth going into the question as to whether the investigation was justified in charge sheeting the petitioners under for the offense of abatement of prison. Therefore, should I admit the matter? Admit it. The criminal petition is admitted for hearing. However, in the context of what is stated above, it is directed that till the next date of this initial, the further proceedings in which one should be stated?
Yes, Lordship.
Which one should be stated? Further proceedings in
Other proceedings.
TRC number 47 of 2025, pending in the court of learned J. Matsu, Hokuakan, shall remain stay. State what to go. List after the vacation on, should I give a date? Better to give a date. November last week. Any date? 28/11.
Yes, deeply obliged. Lordship,
Let us see what happens.
Lordship, may I know the common order for all three cases?
No, I'll give separately, but it will be contents will be similar. Yes. I have not gone into the same, no?
Same. Only difference is that item number 17, these persons are arrested, other persons are in anticipatory.
In 735 also you are there. 16 item number.
I said, 715.
15 item number.
735, criminal petition 735, item number 15.
15.
He is also,
Your name is there.
my name is also there, he is also.
So, what? Itu Bailable, it also, the only thing will be different in this. As per office note dated 6/9, service report upon respond number 2 informant is received back after due service. Again, bill admitted. So, list along with in this case, this 16.
Yes, 16. Only one petitioner is there. She has filed the first case. And in anticipatory bail, she is also.
So in this case also you are there, same counsel.
Same counsel. He's not there, but
You are there. Okay. And in one case you are also. No. In this case, in this case, what should you do? Should you take a first step? Service and response or see check.
Lordship, direction may be given to take a step. I will take again. But Lordship,
Just a minute. As per office note dated 6/9, service notice upon respond number 2 informant was sent to learned DM Dhokwa on 3/7/2025. However, service report not received back.
Lordship, DM Dhokwa is subdivision. There is no DM.
No, I thought that it's an administrative, because nowadays many new districts are there. Judicial districts. Dhokwa in my opinion, at least it's not a judicial district. Sign. Let's say Kodia is a police district, for example. But for us, it's a subdivision, right?
Dhokwa is a subdivision. Lakhimpur is the
Subdivision under Biswanath or Lakhimpur.
No, Lakhimpur. Under first step for concern OC and
The petitioner may take first steps upon responding number 2 to the office of the concerned officer in charge of Dhokakana police station. Dhokakana police station. Order of stay is same. Yes.
Deeply obliged, my lord, my.
This judgment, if you need for preparing, you take it.
No, lordship.
But I'll have to make a note of the name. Then. I also want to study. You take it back. You may need it for studying.
Okay. No need, lordship, no need.
Should I keep it?
Yes, yes.
Take it another copy.
Lordship, may I pray that only one thing, lordship. As these cases are fixed on day after tomorrow.
Bail.
In trial court, as lordship has granted stay,
No.
may I receive order tomorrow, by tomorrow?
Yeah.
Uploaded order. Deeply obliged. Deeply obliged.
Sometimes I can direct the urgent photocopy be given to the petitioner, but that will be not necessary.
Not necessary. No, but,
You get it. Upload to priority basis. Record of some. Download programs, soft copy. So let us take up your matter. You've been waiting. It will be something. It will be. 47. We've been waiting. This is one of the challenging or say stressful part of it. Waiting. Maybe you can have better time management. Management systems, technology.
No, this was basically for quashing of a charge sheet, the PRC. And in fact, during the proceeding, what has happened, we had filed a writ petition, which was, WBC 3901.
Wife had filed a writ petition.
No, but the husband.
Husband.
There is a provision under the Air Force Act for providing maintenance to the wife. Since the amount was unreasonable, we challenged it by way of a writ petition. And in that case, the matter was referred to mediation. And in fact, I'll just.
Right.
During the mediation proceedings, the entire cases were settled. In fact, the present day they are divorced. And if your lordship kindly comes to the first page, last part I have marked it. Whereas by the order of the Honorable Court dated 16/12/2024 passed in WPC 3901, the matter was referred to the mediation and appointed as so and so. Whereas a mediation by mediation case number 32/24 has been registered by the Guwahati Mediation Center. And lordship will kindly come to clause 8. Page 4, clause 8.
Yes.
Your lordship, in view of the settlement made by the parties, they will approach the Honorable Court and submit a joint prayer for closing the criminal petition 190/22, pending before the Honorable Guwahati High Court as well as the PRC number so and so, pending before the learned judicial magistrate. Sorry to dispute. So, the only thing here, because of the settlement, lordship may quash the proceeding. Only thing there is since the cases under 498 and 379, non-compoundable offences. The lower court will not have the power. There is a judgment of the Honorable Apex Court, your lordship.
Jansen, sir.
In fact, B.S. Joseph and others, that is a 2003.
Yes, Joseph was given previously.
So,
Washing is not a problem for non-compoundable.
So now, only thing since the parties are agreed, in view of the settlement arrived at, lordship may quash the lower court proceeding.
Take your submissions. Your Mr. Boros. Yes, Yes, Writ petition was filed in, for In what connection? Was it
Yes.
service matter?
No, my lord. What has happened, my lord, in the Air Force Act, my lord, here's a,
Oh, compulsory mediation.
no, there's a section 20, no, there is a provision under the section 92 of the Act, my lord, which provides for maintenance to the wife. So, my lord, it was also a matrimonial dispute, my lord. When there is a matrimonial dispute, the wife makes an application before the authorities. When the amount is fixed by the authorities, we had challenged that. But during that proceeding, my lord, we came to a settlement that we have paid certain amount of money.
Approach the
And
airports authority.
yes, in fact, my lord, in fact, they have presently divorced also. We have already filed a divorce, a joint application, my lord, and they are divorced as of now. And whatever cases were pending, my lord, we are withdrawing one after the other. And this is one of
Mediation was arrived at here.
here.
Mediation, our mediation.
Yes,
center.
that is referred to it in the second page, my lord. I have marked it, my lord, so for the petition is concerned, and the second page, there is a 32 of the.
Okay, sit down and. The criminal petition 190 of 2020. The petitioner hearing Sachindranath Dey invoking the powers under section. This will be 482 CRPC 1973. Is seeking quashing of a charge sheet dated 31/1/2021. Filed against him under section 498A 379 IPC. And the case pending before, and the case in the form of ERC 841 of 21 is pending before the court of learned CJM Sonipur. The respondent number 2, Munmun Panit, stated to be the ex-wife, stated to be presently the ex-wife of the petition. On 10/10/2020, she had filed an FIR before Thekiajuli PS with certain allegations, resulting in Thekiajuli PS case number 632 of 2020 under section 498 case 379 IPC. The investigation of the same resulted in a charge sheet within bracket CS 6 of 21 dated 31/1/21. Against the present petitioner. And charge sheet was filed under section same sections, right? 498A. Only 498.
498.
Not
70
379.
No, no.
Under 498 IPC. Subsequently, the aforesaid PRC case was registered as already stated above. Third to third R D assistant file. Your good name, please. Your name. And please D Bora for small number 2. Should I record DP Kusami learned additional people? You have to say something. No? Additional people in the state. Respond number 1. This settlement is not annexed, right? It's not annexed.
During the proceeding.
Is it?
That is why, my lord,
It's not annexed, right?
no, no.
Both the parties have, the learned counsels for both the parties have placed before the court the deed of settlement dated 11/3/2025 which was entered into pursuant to efforts at mediation in the mediation center of this court. As per the settlement, within bracket, para 3, the parties were to approach the concerned learned court at Tejpur for divorce, and in this context, it is submitted that accordingly the parties did so, and now they are the parties are divorced by mutual consent. The learned counsel has drawn my attention to the arrested me. one case allowed to go on bail.
Well, this is the case now. It is shown against her, and this is shown against. We got it, whatever it is from the website. Website it was. Third page, your loss case, third page of the, this. Third page, your loss. In my case, my it is filed by medical council. And when it's filed by the affected person.
That's another thing.
Yes. Now you kindly see paragraph, my lord. FIR is become lengthy, but here in this case only page 16, my.
Doing a surgery, if you're not trained for it,
It stated, my lord, the registered number which was given in that here, my lord, that is not available in the office. Not in alternative medicine. That I have, my lord, annex your lawful fine. I am doing, my lord, as per this alternative medicine, my. Only I sometimes, my lord, the surgeon take my help for the equipment was assemble, my lord. Not, I cannot do it, my. Paragraph 5, your lord, kindly say, have paragraph 5 of my petition. How I can involve, I have written, my lord. Paragraph 5.
alternative medicine, people are allowed to write MBBS.
No, surgery not allowed. Page 12, you look certificate. It is written what I can do. Page 12, now. But I admit, madam, that's true. I am not on that, madam. I admit, madam. But he has not made any surgery, madam. That is what I'm saying. This allegation is against only he has written MBBS. That is the author. And page 12, kindly say, madam, what he can do. Indo-allopathic medicine, madam. Page 12, his certificate. Important directive, my lord. Page 12, bottom. This is valid, no question about this certificate. But I am doing this now. Indo, Apollo, allopathy.
Anyway,
Madam, I am my only.
this is the AB or? Arrest.
Yes, 44 days to the madam. And everything seized, madam. Everything seized. And no private person has made a complaint except that one which already yours.
See, he removed according to the allegation.
Yes,
You the right healthy ovary of a woman.
that is.
Obviously, tomorrow I try to do a surgery.
That's not
Something
that,
like that.
nobody can suffer. I also can. I should not mind.
You're being a professional.
Regarding solution of alternative medicine. Everything is there from the case study. You actually receive the advertisement of a qualified doctor, MBBS, specialist in chemical medicine of medicine. His advertisement and of the other specialized.
Now, my lord, some of the nursing home point of number. Now, my lord, some of the nursing homes like the hospitals, wherein the present, my lord, doctor is, my lord, involved, my lord, those are also considered as part of the investigation. Because without this, the person can trust the parents, and city also. Without having any UPS from some of the Indian medical, nothing, my lord. And my lord, police has also verified from various sources from the, my lord, other institutes, my lord, where he has shown that he has obtained MBBS degree. Everything is possible. Regarding that, my lord, report is also available. And my lord, how he is playing with the life of the innocent, my lord, victimized person. Regarding that 180 statement of the victimized patient is also available. Also, I can see this report. Along with the evidence found during investigation. And on the basis of that, my lord, statement of the victim, that term of the DMS is also, my lord, again against this person. Actually, attempt to murder, my lord, this also need to be, my lord,
No, not attempt to murder, knowledge.
Knowledge.
Such negligence is such a high, my humble opinion, and the negligence level is such gross that it crosses that limit of negligence and goes into the, the area of knowledge to cause death.
Yes.
But at this time, not on that. I am only everything safe, investigate almost.
Yeah,
I am only on that, my lord.
fair.
Nobody can support this type of
Nobody
thing.
can support.
Nobody can
But
support.
tomorrow we may be another.
Yes, my lord. Nobody can
I
support.
mean, actually, these things are easier in
So my,
places which do not have much
Yes.
medical facilities.
but ultimately 60 days when it will come after 10 days or 15 days. So I am only my said I absolutely am with my friends. My lord.
But he has not passed his 10 plus.
Fair counsel.
Allegation and thereafter investigation, everything is there.
Complete quack, that means.
Yes.
Yes. But the investigation complete, my lord.
This type of person.
That's true.
Like those hospital.
Hospital should also verify.
I am not defending my lord.
I understand, no problem. We have to do our respective professional. Which statement you wanted me to read? 164?
One of the victim.
No, I'm fine.
But only one victim.
It
filed
is-
that
yes.
No other case filed.
No, it's him. Bail.
Regarding other points for the investigation of the emergency.
They should also
Make their.
Let us take care of this. now.
lack of regulation actually. So suppose tomorrow we go to Apollo Hospital in Chennai, we go and we have faith. It's not the doctors. Doctors are there. We have the faith that here good doctors will be there. Something like that. These things. Should not anyway, but this is regulatory failure, hospitals failure, the person's faith. Please sit down. Senior counsel in charge.
Another thing, Ernest Kumar not followed, that is also I have to take. Complete terminal, 41 notice.
Okay, what it-
Page.
Instant bail application has been filed under 483 BNSS. Seeking bail for accused Pulok Malakar, who was arrested on 3/8/25 in connection with Silchar PS case 786. 2025. The gist of the allegations the Azahar dated 29/7/2025, lost by Medical Council, Assam Council of Medical Registration, on behalf of the Assam Council of Medical Registration, is about the present accused illegally practicing about the illegal medical practice of the accused herein, even though he's not a qualified allopathic doctor. He's alleged that he has also been conducting surgeries. The learned senior counsel have fairly submitted that two other cases has also been registered against him, but he has been enlarged on bail in one of them. So, the learned additional PPP portable submit the case diary and vehemently opposes the grant of bail. It is submitted that he has already caused irreparable damage to one patient by his illegal acts. And pointing out to a document, the learned additional PP submits that the concerned accused has not passed health standard. I peruse the statement of one lady recorded under 183 DNSS. Considering the nature of the alleged allegations, the materials, it may not be prudent to grant bail to the accused at this stage also. Accordingly, the bail petition stands rejected. Return back the case that is supposed to not be proper. Let him
At this stage.
at this stage. With this. Yes, you can take back. Are you Chaudhary? And he kindly give his name to the system.
Obliged to.
Chaudhary. Right. What was it you have mentioned in the morning, no?
Yes.
One was revision, one was.
Yes.
Criminal petition.
Possible.
Actually, my lord, it is a proceeding under section 145 CRPC pending before the
You are
Trial
seeking,
court.
one party is seeking quashing the entire,
and the other.
he's seeking, and
and
you
he
are
filed
seeking
a petition for quashing.
for quashing the order.
Yes, quashing the order as well as the proceeding.
Actually, I just tried an
I thought,
experiment
let
today
it
that
be taken
trying to
on-
take
On
hearing in the
Tuesday,
morning. But now to next week will be only motion day,
Tuesday at 2 PM,
next Tuesday.
is it possible?
No, I can fix, but most probably next Tuesday will be, next week will be motion week only. The non-hearing matters only because of vacation. That was
Thursday-
earlier practice, but as you know, but now also I was told that. it will be the practice.
Thursday,
Right, it will be the practice too. Good. It's a bottom. Next week likely to be non-hearing week. That is still the practice.
the Thursday, my lord, at 2 PM.
Don't keep it next week. Either we do it this week or after vacation.
Next week. That's because my lord, the proceeding has been pending, has not been disposed of due to pending of these cases before this honorable court.
We can try on Thursday. Yes, Thursday we can try. I don't even know whether I'll keep this practice. It's just an experiment. Let's see. Because hearing matters were not not reaching at all. So when will they, this is a new matter, it's comparatively. Like 12, 13 matters are pending, 11. If you want, we can fix it on Thursday or we'll take it after vacation and finish.
It is after your lordship.
No.
After-
Not only my opinion, you also. Your opinion is also important.
Thursday or Tuesday or after vacation.
October. After vacation, any better to fix it on a hearing. Hearings too.
Can it be, my lord, on Thursday or Tuesday?
This Thursday,
Yes.
your friend agrees.
No, if it is taken up at 2 p.m. on Thursday, but I'll be finished.
Understand?
Let us try.
What do you fix on Thursday?
If it is not released, then it will come for vacation.
Okay, this the matter, will not be taken up to some positive time. This is the matter of. Time, because I don't know what matter should be there actually on that day. Next week. Well, this is the matter on Thursday. And therefore, do we need to take up the matter at or around 2 p.m. Yes. Around 2 p.m. Right.
Must have been.
Then Thursday, 9:30. Doubt whether there'll be matters, because now vacation is approaching,
Yes,
it is
yes.
already, well, naturally, people have to file their petitions. Yes. So take a chance on Thursday.
Yes,
If it does not work after vacation,
Yes.
then maybe
Yes.
28 we can take, no? 28.
much have been.
Not, no, let it come on Thursday. Let it come on Thursday. Let it come. Maybe sometimes we may be able to. Then after, otherwise 28.
13.
Senior counsel is busy.
Can the matter be fixed on Thursday or Friday?
Thursday. No, is there, because we have to see whether the charge sheet is justified. Therefore, the investigation has to be seen. What statements, whether the charge sheet is justified. So CD will need.
Scan copy of the case diary.
Yes, case diary and charge sheet. This matter could not be taken up this hour as the learned senior counsel in Chopin stated to be preoccupied with another matter in a different court, in a different bench. Some learned additional things, it's that the scan TCR, sorry, the scan CD and charge sheet has to be procured. Accordingly, issue requisition for scan copy of the case diary along with the charge sheet. In that case, after vacation. Date may be fixed then. List after vacation on. You can suggest. Thursday. 16:10, okay?